Functionality. Court officer. Court officer.
We have been waiting, but
ಹೇಳಿ ಸರ್.
ಅದು ಡಿಲೇ ಆಗುತ್ತಾ ಸರ್? ಸಿಟ್ಟಿಂಗ್
ಬರ್ತಾ
ಇದೆಯಾ?
ಇದ್ದಾರೆ ಸರ್.
ಬರ್ತಾ ಇದ್ದಾರಾ? ಸರಿ
ಬರ್ತಾರೆ ವೇಟ್ ಮಾಡಿ.
ಸರಿ ಸರಿ.
list to ಇರ್ಬೇಕು ನಮ್ಗೆ ಅದಕ್ಕೆ.
My lord,
Yes, Mr.
my lord, on the other day, my lordship had disposed my case regarding that pollution control board. This one on 21st in 10374. Taking the first and treated the closure order and showed the order of in one more petition before this court not to close this one. On 21st, my lord has decided they have predated this one on 19th.
The order is available.
Order is available.
Fresh commercial appeal. Fresh commercial appeal. It's against a Section 9 order rejecting my Section 9. In fact, I was before your lordship when the ex parte relief was rejected, and seeing the urgency, your lordship had given a direction to dispose of the petition. During the proceedings, I am entitled to suspend rents. I had deposited before court. The court has allowed them to withdraw the rents which I have deposited. Could it be either on Monday or Tuesday as per your lordship's convenience, Manoj?
Used.
Grateful, Manoj.
Being spoken to. So all matters which may be mentioned or be separate vote. Separate.
Deeply
All
appreciate.
will figure on separate. Those
Please.
mentioned and granted.
Please, Manoj.
Because of paucity of time, yes.
No, being spoken to.
Pardon?
No, being spoken to. The matter is put up a sun for 2020.
Being spoken to tomorrow. Not tomorrow. Tomorrow.
Your lordship, serial number 59.
What is the urgency? What is the urgency? Urgency, what is the urgency? We'll have it, but what is the urgency? We are bound to have it, but when it is the question? 10th of June. What is the urgency? 18th of June.
That's
June.
that's yesterday. That's a matter pertaining to appointment of chairman of Pollution Control Board got
That is,
adjourned.
we are told that it is pending to learn a single judge. By a writ of co-warrantor.
This petition before my lords is earlier in date and asking for the exact same relief with regard to the exact same notification, my lords.
Maybe
When we
you
made
may
a-
be right, but on judicial side will not
On a-
take
on
any
a making
initiative
mention-
you mentioned whatever
Yes,
you,
we made
you
a
file
mention-
a note you mentioned, but on our own we will not be able to.
We
Nor
make
will
this,
incline to do.
That's we made a request before the single judge, my lords. Single judge was like, make a request before the division bench.
So filing not be registry, that these are the common matters. Then administrative side, yes, but on judicial side will not be the getting the matter from the roster of the learned single. Not on
Lords,
judicial.
it should not have gone there. My lords. It should have ideally come before my lords. The matter should not have gone there. It should have come before my lords because it's a green bench matter.
Even then, now it is notified, and you just file a note and it will be placed on
We'll
administrative
file a note before the court, my lords, and the registry also.
registry.
We'll file a note before the registry. A copy also was filed before the court. We'll do that, my lords.
Serial number 35 in today's list. I appear for respondent number 7, my lord. Seek short accommodation. I've taken permission from the council for the petition.
What is the PIL?
My lord, the allegation is, my lord, that the building constructed by me is not in accordance with the sanction plan.
After vacation,
Very good.
20th June,
Grateful.
as requested jointly by Lord.
Serial number 9, Your Honor. Serial number 9.
9.
9.
Yes.
I want
PIL.
2 weeks time may be granted, Your Honor,
No.
for want of necessary pleadings.
Refuse. You remain present. I will discuss. Yes. Yes. What is the urgency? I file. What is the urgency? No. What is the urgency? 20th. 20th. You take time there. 23rd of
Lordship's
January.
permission.
Your Lordship,
madam.
serial number 59, Your Lordships. 2 weeks time may be granted after the vacation.
This complaint for filing the minimum of construction over a scheduled property. It is a
No.
scheduled property is a public playground, my lordship. The matter is posted after vacation till complete.
25th of
It may be taken
June.
up on Monday, my lordship. Please, my lordship, I beg your lordship to post this matter on
You
Monday.
may request but not post. Nor there is an urgency. 25th of June.
Your Lordship, serial number 59.
He gave us date on March 10th itself to be listed.
Pardon?
Your Lordship already gave us date to be listed this matter on March 10th itself. In spite of doing office of judgment complaints and all, the case is not yet listed. And Your Lordship, in spite of giving the status quo order by this Honorable High Court, the respondents has not maintained that status quo order and have violated the terms. And they have already put the construction, and in next month they have putting the opening ceremony of a commercial complex in the same social property. So Monday or Tuesday, Your Lordship.
File IA.
It's already filed.
IA.
IA.
After vacation. 9th of June.
My lord.
This matter was listed, I removed it, my lord, because it's a matter of compromise, also directed to listed 230. But it was listed on the day with the process, it was urgent for 4 weeks. Been told to file an IA, I filed in my IA. Taken tomorrow for recording compromise.
Get it listed. Monday.
Monday.
Serial number 62, 63. Some office objection is raised by the registry that instead of commercial application, I filed the commercial appeal. I seek the permission to convert the commercial appeal into the application. I filed the one IA before the trial court to transfer the case before the commercial court. This transaction between the parties is commercial transaction. They are filing in 2019. When two suit has been filed, and in that we already filed the section 15 to transfer the case before the commercial court. They are not filing. They are not. The honorable court will not pass any order. After that, 2024 also filed. That has been rejected.
So when you file the application as section 15 for treating it as commercial matter, we will not permit you conversion until that application is decided.
Then that is already there. Dismiss in 2025 March.
So then you let it be called out. Then
After vacation. After vacation,
we are not. Current you withdraw and file the press. 62 and 63.
63, 60, 62, 63.
62, 63. Learned Advocate Mr. A. Gopi Krishna, Gopi Prakash, for the appellant, seeks permission to withdraw the present appeals, seeking further permission to what you want to file press.
I want to convert this to my file.
We want to file a fresh one after with a fresh one, sir. ONES with different nomenclature. Full stop. Permission to withdraw the appeals is granted. Withdraw both the appeals are permission to withdraw both the appeals is granted. However, without expressing any opinion about the conversion, about the converted appeals which may be filed.
Lord, serial number.
Which is permitted to.
With the kindly of this court, my lord.
Serial number 58, my lord, sir. I'm appearing to the respondent, my lord.
Lord, effect kindly can be 2 weeks time, Lord.
58.
My Lord, effect the petitioner. 58, my Lord, 15, my Lord. May be taken in due course. I'll persuade my Lordship regarding, and let my senior counsel today, my Lord.
He is seeking time.
My Lord, but it's for orders, my Lord, for the petition, appellant to come.
That will see maintainability. When it is no urgency, then let it go to 19th of 2nd of July.
Lordships kindly,
July, learned ever the respondent.
With the kindly of this
To
court,
which
my lord.
learned ever
kindly may make a
appellant-
submission, my lords.
appellant does not. Yes, anybody, yes.
Serial number 38, my lords. I'm the
I appear for
respondent
the
number
appellant.
1.
Appear for the appellant in 38, my Lords.
38.
And I'm a complainant in 38.1, my lords. At the last instance, my lordships had some inconvenience. May I seek my lordship's indulgence to adjourn
4th of July, as requested. 4th.
any date?
Yes, now online mentioning. Yes, anybody?
Lordships
Nobody,
kindly
yes.
may make a submission, my lord. Second list,
Yes.
first, only one matter is there, 1.1. I'm up in the petition. I'm not well today, my lords. Lordship may give me a short accommodation.
Which serial number?
Second list, 1.1, my lords. There is only one matter, second list, 1.1. I am for the petitioner. There is no interim order also. Lordship may kindly grant me some because I'm not well today.
Serial number?
1, my lords, 1.1.
Where is the serial? Tell the serial number. Otherwise, we have no time.
Second list,
Which
1.1,
serial
my
number?
lords.
Your matter is listed at which serial number, Mr. Counsel?
1.1, my lords. Secondly, one matter.
There is no 1.1 here. Yes.
Second list, there is one matter.
Only one matter in not second list. I am appearing in first matter. He is requesting time in second matter. 1.1.
We don't have the second matter. You come
Your lordship,
physically.
serial number 59.
It is there.
Your lordships kindly.
I am also not well. Lord, maybe taken up.
You are also not well. And you are making both of us unwell.
No, my lords. I never asked for an adjournment today. I'm running temperature. That's the reason why.
This is meant for disposal.
No, Lord, I am not well. Lord.
Is it?
Lord, my matters to be heard finally. Lord, pleadings are complete. We are
Especially for you
maybe taken.
after vacation.
Your lordships
He will-
kindly.
it's-
Your lordship, serial number 59.
Your lordships kindly.
Yes, anybody online?
Serial,
59.
serial number 59, your lordship. 2 weeks time
Yes.
may be granted.
At the request of learned record, the appellant stand out to 17th of July as prayed for.
Your lordships kindly. One matter. Posted to 7/7, Lord. Civil contempt matter. Borrower's contempt petition is there. Possession is with the bank, Lord. I am without Lord, recourse. I am not able to conduct my business. My business is shut. My Lord may please have it Monday or Tuesday.
No,
Or immediately after vacation.
immediately after 12th of June. 12th of
My
June.
lord, with the kindly of this court, my lord, serial number 38, any date, if my lords can. Serial number 38, my lords were pleased to adjourn, but any date, if my lords can.
It is already given. No matter will go without.
Grateful, my lords.
Any other mentions?
Serial number 59, your lordships.
59. Yes. What is that?
After vacation, your lordship.
It is already given. 17th.
Please, your lordship. Obliged.
Contempt matter. Serial number 1. Mr. Sirajin Basha.
This is electrocution case. Compensation is awarded.
We have
but they have
preferred-
not deposited.
We have preferred SLP, my lords. Matter is listed today for hearing.
You better withdraw subject to outcome of SLP.
Okay.
Otherwise, this is time barred. Learned additional government advocate Mr. Pramod states that the special leave petition is preferred in respect of the order which is brought under the contempt, present contempt petition. In this regard, learned advocate for the petition so would respond that he would prefer to withdraw the according.
Serial number 2. Mr. Nurama.
It is a clear direction by the division bench lords Just kindly see the Lords, the operative portion of the order at page number 13, Lords. Lords, the order of the tribunal dated so and so shall stand set aside. But the competent authority shall consider.
Notice returnable on 13th June.
Lords, notice is already issued, Lords. Notice is already issued.
Already issued.
This is barred by limitation.
What is?
And also there's no time limit.
Similar matter was there. Isn't it? Earlier? I don't know. Your endorsement is there? 19/11/20.
Yes, Lord.
So what is that? What is that endorsement?
Lords, on the same lines, Lords, the division bench has Lords directed them. Division bench has directed them to consider the application of the Lords to petition the complainant. Lords, without referring to Lords that she is married as on the date of the Lords application. It is an appointment for compassionate.
That is on the merits. You file a separate proceeding.
Well, file.
So the directions of learned single judge in order dated 18th September 2024.
The direction of division bench
was to consider the case of the petitioner for grant of compensatory appointment. Where is the order?
Lords, page operative portion page number 13 Lords, 13.
In accordance with rules in force, without raising the objection that the
he is a married daughter.
Petitioner is a married daughter. Full stop. In response to this contempt petition, compliance affidavit is filed in which the respondent gives copy of the endorsement of the order dated 19/11/2024, whereby the claim for compensatory appointment is declined. Also, while learned advocate for the petitioner, Mr. So-and-so would urge that the ground mentioned is not sustainable, the merits of the ground of the order, public endorsement, cannot be subject matter of consideration in the current contempt jurisdiction. In that view, while the petitioner to challenge the endorsement dated 19/11/24 by filing appropriate independent proceedings in accordance with law, in respect of it, this court does not express any.
Already there is an order, Lord. Already there is an order, Lord.
But we have here, my lords, we have.
Don't go in merits in the contempt jurisdiction. Next.
Lords, may I make one submission? Here we have preferred SLP, my lords.
Nothing good. Yes.
Seal number 3, Rohit Rao.
Preparing for the complainant, my lords.
Yes. Where is the order?
My lords, Annexure B, page number 43.
It is an interim order.
Yes, my lords. My lords, not the interim order. There was a specific order by this Honorable Court in writ petition 27539 of 24. If my lords may permit, I may read out the order, my lords. It's dated 5/12/2024. The sale certificate to be issued in favor of the successful bidder, subject to the outcome of this petition. However, the respondent in this case has already issued the sale certificate, my lords. Well, the matter is still pending. The sale certificate is issued on 18th January 2025. Subsequent order is Annexure C, my lords, page number 43. Even this order, my lords, there's a specific direction of confirming the sale alone and not issuance of sale certificate, my lords. Despite this, there's a willful disobedience of the order, and the sale certificate has been issued.
The sale is confirmed?
Sale has been confirmed and the sale certificate has been issued, my lords, already. The matter is still pending. It had to be heard on merits. In fact, there is a violation of the IBBI regulations as well, my lords. Regulation 33, Schedule 1, the liquidator was purchased.
Identical. Same order.
My lords, in the same petition, the first order that was passed on 5/12, my lords.
Where is that order? 5/12.
5/12 is on page 42, my lords. If I may read, my lords, the sale certificate to be issued in favor of the successful bidder, subject to the outcome of this petition.
There is no 5/12.
but the sale certificate has been issued, my lords. In fact, this has also been acknowledged by the liquidator in this SEC meeting, my lords. Annexure D, my lords.
Who are you?
I am for the complainant, my lords. For the complainant, my lords.
Let we know what is your status.
My lords?
What is your status in the proceedings?
My lords, we have been the managing director. We are the sustaining managing director, and the sale certificate has already been issued.
Where is your petition?
My lords?
Where is your petition? The next.
Yes, my lords. The annexure A is the writ petition, my lords. At page 21. At page 22, my lords. 22.
Dispute saying that it's much more better. The limit single judge observed before the carpet data can bring a better offer. If it is a subsequent date, if you get a better offer, it will be considered. Unless it's the first part of bringing the better offer was part of the compliance. Series of orders are passed. So you are giving better offer?
My lords, apologies.
You are giving better offer in the auction.
My lords,
So go and give before
my
a single.
My lords, my lords, if I may make the submission.
And this is specifically made subject to outcome of the petition.
My lords, yes, my lords. I'll make it just one submission, my lords. On 20th itself, the 4 weeks time was given, and 4 weeks would ideally.
What is the contempt?
My lords, the contempt is that the order has been specifically mentioned that the sale certificate has not to be issued subject to the outcome of the writ petition, my lords.
Then?
My lords, the sale certificate has already been issued.
When?
It is issued on 18/1/2025.
You say it will remain subject to outcome petition.
My lords, it's already been issued.
So we'll still say subject to it will still remain subject to outcome of the petition. Why should we entertain the contempt petition?
My lords, the contempt petition has to be entered only on, entertained only on the aspect because there's a contempt of the specific order, my lords. There's a specific direction, my lords, which bars the issuance of sale certificate. And despite that order, in fact, my lords, if I can take you to Annexure D, my lords. Annexure D, page 47, my lords. There is a specific admission by the accused there. Para G, my lords. Page 47. If I may read, my lords. The allegation was
when the sale certificate issued?
My lords, the sale certificate was issued on 18/1/2025, my lords.
18/1.
Yes, my lords.
You could have pointed out to the learned single judge it was already issued when the interim order is granted.
My lords, we are trying to get the matter listed, but we are unable to get that matter listed, and that's why we filed this contempt petition.
The order is passed on 5/12.
Yes, my lords. On 20th.
Issued on in which date? 18/1/25.
Yes, my lords. My lords, 20th. My lords, if I just make this one submission, on 20th of December, the opportunity was given to us to file a better offer within 4 weeks, and that 4 weeks ended on 20th, my lords. And we have submitted our better offer by 21st. Meanwhile, on 18th itself, the sale certificate has been issued, which is a clear violation of the 5/12 order, my lords.
What will remain? This liberty will remain. Full stop. Learners counsel for the petitioner, Miss
Aishwarya,
so and so,
80.
would want the court to initiate the contempt proceedings against the respondent in respect of the alleged violation of order dated 5/12/24, read with order dated 20th/12. Order dated 5/12/24, the single judge of the successive bidder shall remain subject to the outcome of the petition. The petition was then directed to be listed on 13th of December 2024. Earlier, on 20th/12/24, on a single judge recorded. Again in the interim order, subsequently passed, that in the event no offer is made by the corporate debtor within 4 weeks from today, the respondent liquidator is at liberty to confirm the sale in favor of the auction purchaser. Full stop. The grievance is that the sale came to be confirmed prior to the aforesaid date. Therefore, the contempt is committed. Full stop. 2 weighty reasons, paragraph out of 2 weighty reasons dissuades the court from entertaining the present contempt petition. Firstly, the order is interim order where the rights of the parties are still to be gone into and have not been finally determined. Full stop. In the second place, the liberty for the corporate debtor would continue to operate to give its offer. Full stop. Reserving such liberty to be availed before a single judge, and further reiterating that the sale certificate which is confirmed, shall remain subject to outcome of the main proceedings of the writ petition, which are pending at large before a single judge on their merits. The present contempt petition is not entertained and stand dismissed.
This number 4, Mr. Vijay Simha Reddy.
I got the complaint.
Order.
Order of this honorable court is at page number 9, my lord.
9.
It has not been complied, my lord.
Where is the order?
Page number 9, my lord.
9, there is no order.
Relevant portion is at page 21, my lord.
20.
The petition is allowed, my lord. The penalty order has been set aside.
Delay is delay.
Do you know it? Yes. What do you want?
They had
What is your status?
we made a representation.
It's not maintainable because of the delay. my lord.
Because
And
it is
the
delay.
time is also not stipulated.
We made a representation, my lord, enclosing this order. He has already been retired, my lord. Even pensionary benefits have not been settled, my lord. On earlier occasion, we made a representation, my lord, on 15/3/2022, my lord. It is page number 23, my lord. Translated copy is at 25.
While allowing the petition, court set aside the order of punishment dated 2/11/2018. Consequently, held this, which was withheld during the course of the inquiry, which had culminated into the punishment order. Full stop. The aforesaid directions are brought under the contempt jurisdiction of this court. Full stop. It could be readily seen that the order came to be passed by a single judge as big as on 5th March 2022. Full stop. The present contempt petition came to be filed on 29/3/25. Full stop. Section 20 of the paragraph, Contempt of Court Act 1978, reads as under the court the section. Full stop. The above provision is clear to prescribe that the contempt application has to be filed within 1 year from the date of arisal of cause of action, or when the date when the contempt could be said to have been committed. Full stop. Evidently,
You made a representation earlier, my lords, page number.
much beyond 1 year, when the contempt could be said to be can be said to have been committed, and cause of action to file the contempt arose.
Is it continuous?
The end of 1 year period from the cause to file the cause of action to initiate the contempt proceedings shall stand terminated by virtue of the operation of the aforesaid provision. Full stop. The embargo operates in this case. Learned advocate would submit in vain that representation was filed. Full stop. Filing of representation will not extend the period of filing contempt, which is a statutory embargo. Petition is dismissed.
Liberty at least to pursue them, because it is regarding promotion.
You
And
withdraw it.
yes, already retired from service.
Sorry.
Number 5, Stenesh Sriraj Goda.
It's the order of the learned single judge, my lords, is page 15. It's for change of kata, my lords.
Notice returnable on 17 June.
Grateful.
Seal number 6,
I pay for the complaint. The order was direction to consider the application for e-kata. It has not been complied with. The order is at page 17, my lord, and operative portion at 19. The petitioner is accordingly disposed of directing the petitioner furnish documents. Thereafter, Panchayat shall consider the same,
Notice
pass an order
returnable
within
on
period of 3 weeks.
18th June.
With pleasure.
Seal number 7, Mr. Kiran J.
Coming up for the first time, my lord, the operative portion of the learned single judge order is 23, page number 23. My lord. Pertains to issuance of TDR, my lord.
Notice returnable on 19th June.
Bless.
Seal number 8,
Notice returnable on. Who is there?
That Mr.
Notice
Sup-
19th June.
Notice. Seal number 9,
Please, sir.
Yes, what you wanted time.
So I wanted
Why?
time because the PIL was filed based upon the newspaper publications.
What is it about?
It is for seeking CBI inquiry for all the allegations and the made by the Honorable Chief Minister at the Legislative Assembly, Your Honor.
All right, after vacation. At the request of learned advocate for the petitioner, stand over to 1st of July. As requested. Next.
seal number 10, PL Mr. Shiva Paumesh.
Petitioners or the villages, my lords. This issue is pertaining to the grant of. Since from 1920, the land was marked as Goma land, my lords, which
This can wait after wait. 3rd July.
Seal number 11, Vishwanath, PL. Seal number 11,
Number 4.
Yes, you are correspondent.
Respondent number 4, my lord. To which time file objection.
So keep it. Pass over.
Writ appeal matters, seal number 12, Mr. Ravindra K.
Prepare for appellate in this case. Impugned order is at page number 11. The National Highways Authority acquired the appellant's land to the extent of 1 acre 4 guntas, which was not utilized for the purpose, As on today also, we are in the position, we are cultivating the land. Kindly see annexure J is the sketch at page number 78, my lord. Between my land and the national highway, there is a government land is there. That also not utilized by the national highways. Unnecessarily, they have acquired my land. We have not received any compensation as on today.
What is the legal infirmity in acquisition?
My lord?
What is the legal infirmity in acquisition?
They have not utilized it for the purpose.
You paid the compensation, not paid the compensation.
NHAI is answering respondent.
Pardon?
Liberty is given to the National Highway Authority of India for them to make a representation to them.
No. Compensation you paid.
National Highway Authority of India, my lords. They
Not
are on
paid,
caveat.
Compensation not paid.
Page 20, para 8, my lords.
So what is the invalidity in the acquisition? You tell us. Otherwise, there is no ground to challenge the order.
Their contention is, my lord, in their objection, statement of objection. Kindly see page number 86, my lord. Para 24.
24 of
Statement of objection.
statement of
Page
objection.
number 86, my lord. 86. In the writ petition, the National Highways Authority filed the statement of objection to my writ petition, wherein they have stated that this land is not utilized. They will utilize in the future. Now what they have done is they have handed the Indian Oil Corporation for putting up the petrol pump. That we are ready to do same thing. They have acquired for only for a meager amount, 10 lakh rupees. Now the property worth rupees crores together, my lord. We are ready to construct the petrol pump for the public facility. If the land is utilized for the purpose of construction of road, we have no case, my lord. The land is still in our possession. We are cultivating the property land, and we have not taken any compensation as on today.
That the learner single judge said that you can claim compensation. Paragraph 5.
Yes, my lord.
You can still claim the compensation.
No, compensation is very meager, my lord. Compensation is very meager.
You can challenge the meager amount further.
Para 8, they have reserved liberty for them to make representation also.
Injustice is caused to the farmers, my lord. They are agriculturists. They are cultivating the land. 10 lakh for 10 lakh rupees. So I cannot buy one gunta of land in their area, that area, my lord. As on today, they are making real estate business. This is nothing but real estate business. They have acquired my land for 10 lakh rupees. Now they are giving it to the IOCL for crores together. If the for purpose, what is the object of acquiring the land? That is not fulfilled by the National Highways Authority.
Heard learned advocate Mr. So and so for the heard learned advocate Mr. So and so for the appellant and learned additional government advocates Mr. Chandrasekhar. Now Chandrasekhar for the respondent. The challenge in this appeal is direct against judgment and order dated 27th June 2024, passed in common insofar as it concerns the writ petition number 3844 of 2016, whereby the petition came to be dismissed. Full stop. The challenge in the main petition paragraph by the appellant petitioner was to the notification dated 14/8/2006 issued by the respondent authority. Under it is 15(9) under the National Highways Act.
Yes, Lord.
Under section 3 of the National Highways Act 1956, whereby the land of the petitioner was sought to be acquired. The land was survey number 18, at measuring 405 square meters and 4 guntas, that is 4 guntas, situated at Aro Bande, Chikkaballapura, Taluka. Full stop. The contentions sought to be raised paragraph by the appellant petitioner before learned a single judge and reiterated before this court for inter-alia that particular land was not utilized. That earlier a piece of land was earmarked for acquisition, which was dropped subsequently.
Milord,
It was,
Milord, my apology, Milord.
yes,
Milord, it is not dropped, Milord.
on a single is
No, Milord, land has been acquired. I produce all the original document before the record, before the honorable single judge. And Milord, Milord, for wayside amenities, Milord, petrol bunk, truck lay bay, Milord, rest house for Milord, commuters.
Lord, we are ready to provide the amenities in my land. They acquire land and they
the
are.
council, the order is started. Interference is not permitted. Please take your seat. That the same was dropped. That the land was kept unused and there was a non-utilization for the purpose for which it sought to be required. It was one of the contention that the land was used for petrol pump. Full stop. We are afraid that the court is afraid that the aforesaid could be a ground to challenge the acquisition in absence of an illegal infirmity shown in the process of acquisition. Full stop. As far as the ground, the land was utilized for petrol pump, section 16 of the National Highways Act contemplates that the petrol pump is one of the purpose for which the land could be, one of the public purpose for which the land could be acquired. Full stop. In the last, learned advocate paragraph wanted to harp upon that the compensation is not paid. Full stop. In this regard, learned single judge has observed in paragraph 5 that in spite of notifying the, in spite of intimation, the petitioner have not received the compensation. The said assertion, it was observed, was not disputed by the petitioner. Learned single judge then proceeded to provide that if the documents, even today, the National Highway authorities will pay the compensation in the manner known to law. Therefore, the aspect of compensation to the petitioners is also taken care of. All the more, paragraph. All the more, the outweighing factor is that the preliminary notification to acquire the land in question was issued on 18/8/2005. The final notification was issued on 14/8/2006. The respondent passed the award on 17/10/2007. Full stop. The petitioner raised his grievance for the first time by issuing notice after a gap of almost a decade on 3/2/16. Full stop. The petition was filed in the 2024. Petition was filed in the year 2016. Full stop. Petition was thereafter filed. Full stop. The petitioner would at the outset is entitled the petitioner appeal to seek any relief against the to challenge the acquisition. The appeal is meritless, it is dismissed. Next.
Obliged.
Seal number 13.
Delay.
I just want to make one submission, my lords. The serial number 5, my lords.
5 is over, madam.
My lords, permission may be given to withdraw the petition at least, my lords.
Withdrawing.
Yes, my lords.
Only 5. Instead of 5, learned advocate Ms. So and so wants to withdraw the petition. In course of the hearing, wants to withdraw the petition. Dismissed as withdraw.
3, my lords. 3. Serial number 3, my lords.
Whichever your matter is withdrawn.
Yes, my lords.
No other matter will be withdrawn.
Yes, my lords.
5, 3, 35, whatever.
Seal number 13.
Yes.
Nobody is there for petition. Delay of 20.
I am for the appellant, my lord.
So delay notice returnable on 2nd July.
Grateful, my lord.
Yes.
Seal number 14. TSB total.
Delay 355 days. Same 2nd July.
Please.
Notice.
Seal number 15. Mr. Sanjay Krishnavi.
Here for the appellant, my lords, I have filed an here for amendment of the prior.
Pardon?
I have filed an IA for amendment of the prior.
Very good. Where is that IA? Amendment.
We haven't received the copy. We haven't received the
Pardon?
before filing with, they have not served.
I've served them
Also, the
through mail. I'll make sure I'll give them the physical copy. I've served them through mail, email.
We do not know. You serve again. Mr.
I'll serve them a physical copy.
Again you serve.
It may be passed over. I don't have an additional copy. It may be passed over.
You must keep 10 additional copies. Everybody would like to have your copies. While learned advocate presses for application for amendment, counsel for the respondent, Miss so and so
Yes.
stated that the
Your
copy
Honor,
is
one
not
more
received. In that
submission.
view, the copy shall be served on the respondents before the interim application for amendment could be taken up. Stand over to after vacation.
Oh, much.
17th
Your
of
Honor,
June.
one
Until then,
submission. There's a
interim order may-
specific document that we want them to produce, Your Honor. If they can produce by next date, Your Honor. Very specifically, they have not added
Whatever you
that.
want to do, 19th June now.
Interim order may be extended.
Interim order, it is granted.
Your Honor, again,
They are doing. We'll keep it earlier. Okay. What is the interim order?
Your Honor, status quo,
Status
at
quo.
least allow us to use the premises, will not alienate it, Your Honor.
13th of June. Chal. Next.
Seal number 16. Mr. Vijay Kumar K.
For the appellant in this matter, my lord. During the pendency of this appeal, appellant number 1, P. Srinath, died on 13th March 2025, my lord. I have filed application to bring the LRs of the first appellant. The application is filed in time, my lord. Application is filed on 2nd April 25. LR application may kindly be allowed, ma'am.
The original petitioners have filed appeal, Mr. Original petitioners have filed their appeal. Are you aware? Your original petition? No, you
Pillappa was the
are
petitioner.
seeking leave to appeal.
Leave to appeal, that application is allowed on.
That we know, but original petitioners have filed appeal.
No, he since expired, my lord, so
By his LRs, they have filed it. In the cost title, it's been shown as such.
One of the children is died. They want to bring of the appellant. So today is appeal or interim application?
Interim application.
For? Where is that interim application? So this Pillappa.
Pillappa was the original petitioner before the Honorable Single Judge.
He is no more.
He is no more.
And who are you?
And I'm his children's filed the writ appeal seeking permission to prosecute this appeal. That application came to be allowed, my lord.
That is already allowed.
That already allowed. And thereafter, during the pendency of this appeal, the first appellant died.
Oh.
And we have filed application to bring the LRs of the first appellant, my lord. Srinath is no more. He died on 13th March 25, my lord.
Oh, allowed. Which is
I'll-
the
I'll-
is IA 2 of IA number?
IA number 4 of 25, my lord.
4 of 25 allowed.
I will carry out the amendment and file necessary amendment.
Yes.
Number 17, Mr. Srikanth.
Appellant in this matter, Lordship. Delay is there, Lordship. Notice may be issued, Lordship.
Notice written, Lord.
And similar matter is on 5th July 2025.
5th July.
Please. Connected this along with you, Lordship. Similar matter, same Lordship. Similar matter is the 5th, Lordship. That this matter also connected that.
It is also coming on 5th.
Yes, Your Lordship.
So both will come together.
Please.
That day you say that both are.
Please, Your Lordship.
This is number 18,
That I appear for the appellant.
Devraj.
The delay of 273 days is there.
Notice returnable on 8 July.
This is number 19, Mr. Satish K.
And I appear for the appeal.
You are the only respondent?
14 days delay.
Only respondent?
No, there are some private parties.
There are
also.
private
Notice returnable on 8 July. Learned additional government advocate, Mr. Chandrasekhar accepts notice on behalf of the state.
Appears.
State and its authorities, number 8 to 11. Rest of the respondents shall be served.
May make one small request, not the, not the appellant was the not respondent before the Lord Learned Single Judge. Not he was arraigned as on his official capacity as Tahsildar. Not Learned Single Judge has allowed the writ petition. Not I am challenging only the portion of the order which directs not initiation of dispute proceedings against the appellant. Not having passed an order under section 136(2) of the Land Revenue Act. Not being a quasi judicial authority, my lord, I have passed the order. It may be a wrong order. Not I am challenging only the portion. That portion may be, my lord.
All can be gone into after delay.
The state government is processing the issuance of articles of charge, my lord. I have passed the order, which may be, my lord, a wrong order. I am challenging only the my lord, page 42.
But we will not be able to grant an interim order if you are pressing for that.
Page 42, my lord.
Page 42.
That is the order of the Honorable Learned Single Judge, my lord. 5. Learned AGA shall forthwith forward a copy of this order to the so-and-so, enable him to contemplate further course of action against respondent number 4. Ensure that compliance report is furnished before the...
Who are you? You are Tahsildar.
Yeah, I am the Tahsildar, my lord. I have passed the order at Annexure C, directing mutation of entry.
That was challenged before Learned Single.
Lord, my order was affirmed by the Assistant Commissioner, which was affirmed by the Deputy Commissioner. all those orders passed by Deputy Commissioner, Assistant Commissioner, and my lord, my order as Tahsildar were challenged before the learned single judge. Writ petition is allowed. All the three orders are, my lord, set aside. Directed restoration of kata in favor of petitioners before the learned single judge. While allowing the petition, my lord, one direction is issued for initiation of departmental inquiry on the ground that, my lord, order passed, they are issuing the articles of charge, my lord.
Then we set aside if you succeed.
I'm
Without considering delay, we can't pass an order. We don't assume jurisdiction over the main appeal unless delay is gone. Isn't it? So, next.
Obliged.
20, Mr. Rajesh Gowda.
Case. Page number 15. Learned single judge. Page number 21, para 14. But after lapse of 35 years, the respondents have filed appeal before the Assistant Commissioner. And earlier they filed a suit for declaration and perpetual injunction was pending. And Assistant Commissioner has directed to allow the appeal, and Deputy Commissioner has been confirmed. And the learned single judge, in page number 21, my lord. And there is no single word of the delay. 35 years of delay, the Assistant Commissioner has not been condoned the delay. And we had relied upon the judgment of the learned single judge, and it has not been observed by the learned single judge. In page number 21, para 14, my lord. And subsequently, the respondent in contesting the property.
You file a suit.
We already filed a suit, but my lord, the respondents already filed a suit for declaration. But after lapse of 35 years, my lord, they filed appeal. But the learned single judge has not been observed the judgments of Chalepo.
So this mutation entry is traced to this registered sale deed, isn't it?
Yes, my lord.
Then
My lord, 35 years of delay, they have not been condoned. There is no application filed by the contesting respondent before the Assistant Commissioner. Delay has to be condoned. There is no single word. Kindly see, my lord, in Annexure B. In Annexure B, in typed copy, my lord. In page number.
How many years? 35 years.
35 years. 1985 sale deed, they filed 2020. We're in position from.
Order is dated what?
But the Assistant Commissioner order dated it, my lord, 2022, my lord, 14/12/2022. In page number 55, my lord. And there is no single word about the delay. Delay application is not filed by the appellants therein. And I'm passing the judgment of the single judgment.
So it is the order of, in the petition, the order's challenge of 22. There is no delay. Delay occurred where? While going to the competent authorities.
But 35 years delay has not been condoned. They not filed even the application for condonation of delay by the.
Where is the first application made by the before the authority, which was delayed?
But they not filed application at all.
Application for appeal, application, whatever. Without,
Yes,
where is that?
No, we are not annexed along with the writ petition.
Bring that.
They subsequently changed the revenue entries and standing trees is there. There is a 35 years delay.
You are saying that particular application or appeal for the competent application was filed. Now, where is that main application? You have not annexed.
Before the single judge, we are not annexed, my lord.
Now we are entitled to ask for that.
Yes, I'm passing this judge.
If it is there, like, please.
Capital B.
No, this is judgment. We don't want this judgment. Bring that application, which was filed after 35 years. Bring that copy.
Can you Monday?
Monday. Bring that.
Great.
Commercial appeals, number 21, Mr. K. Vasant.
Kindly have it after vacation, my lord. We need to file our statement of objection for the IAS yes, file, my lord, for temporary. The senior is out of town.
Well, I served the copies because third respondent.
Senior is out of town due to some family obligation, my lord. We will have to file our statement of objection to this temporary injunction application, my lord. Kindly have it after vacation, my lord. Any day may be fixed, my lord, after vacation.
Well, I've served the copy long ago.
My lord.
Where third respondent is served and respond number 1 and 2.
My lord?
Senior has gone where?
My lord?
Senior has gone where?
Mangalore, my lord. Family obligation, yes, my lord.
Family obligation.
Any date may be fixed after vacation.
At the request of learned advocate, the respondent who stated that learned senior counsel who is to conduct
Because
the appeal
date
is
may be given.
not available due to personal reasons, 10 over 2. When shall we keep?
And at the same time, the respondent one, the notice may be issued to respondent 1 and 2.
Oh, sub on the next date. On 13th of urgency, then little later.
Well, with great difficulty, I could get the appeal posted for admission on this day.
So you're silently accepting what the other side says and what court.
My lord, before all this said, my lord, counsel is family problem is I cannot oppose because then court may say that they don't have the humanitarian consideration so far as the brother colleague is concerned.
13th. Yeah.
Otherwise, your last time you get 29th or the 30th, 29th may be posted.
No, you will not come back from Bangalore, 30th. Bangalore is far.
Well, they are proceeding with construction, that's what I mean.
No, nothing. Come on 30. Nothing, no Evans will go. No Evans will fall. Yes, next.
This is number 22. Mr. Srinivas here.
Yes.
Number 22, commercial appeal block. Case between family members, two brothers started this lease work in this property block, started using this property on lease about 30 years ago. Then one of the brothers purchased it. What I was telling my learned friend Brad was, they will make an effort at persuading them. It's an eviction suit. See if there could something could be
For
worked out.
judgment simpliciter, a learned friend suggests that we could amicably.
You are appellate.
Yeah, and I'm the appellant. I'm the defendant evictee. Direction has been given, but they are brothers, blood. Ultimately, brothers. One brother has died.
We'll make an effort.
I'm the widow of one brother.
To go to mediation.
Mediation, yes, blood.
Allah,
Or else we'll go to his office itself, somewhere in between.
My learned friend could use his good offices also. We'll cooperate and we'll try to amicably resolve.
Settled.
He has all good offices. You don't know that.
In fact, being a commercial matter, DSLA also made an effort. Even litigation, mediation.
Are you
also.
willing to use your good offices for mediation?
So we both will cooperate with each other.
This premises was used for what?
It is used for
Commercial purpose.
prism lights, commercial purpose. I have subleased it.
Sublet.
Sublet it. And that they know, lot. It is acknowledged.
No, it's within my knowledge, it's subleased. I've mentioned it also in my
They
petition.
commenced together 30, 40 years ago, brothers.
What do you want? Both?
We will try to resolve it.
Resolved. Not execution is there today.
I will, once I've said so, I would not
We'll record that.
execute the,
Yes.
till the reopening, on the reopening, the matter may be
Shall
listed.
we record that you are trying to resolve?
Yes, yes, yes.
Learned advocate parties, learned advocate, senior advocate Vivek Reddy for the appellant, as well as learned advocate.
Anil Kumar Shetty.
So and so the respondent jointly stated that since the parties are real brothers and they see the element of settlement in the dispute, endeavors would be made to resolve the issue.
Please.
So for that purpose, they prayed for time, stand over to
Yes,
19th of-
submission, claiming through
19th
the
of-
real brothers, both are deceased, claiming through the real brothers.
It's okay, blood.
9th of June. 19th of June.
Execution, let them not press it.
Allah, once I've said so, I will not.
You will not.
It is my word. I'll not. In fact,
Please.
it is listed today.
Anil Shetty's word is,
Once you have said, then.
yes, yes.
Yes.
Please. Obliged.
Number 23, Mr. Vikram Balaji.
This is an appeal by defendant number 1.
We take to file wakalat on behalf of respondent number 1, 2 also, my lord. Filed caveat on behalf of respondent number 1, my lord. And I take to file wakalat on behalf of respondent number 2 also, my lord.
fresh time to file my objections to the application, for which they have filed for stay.
But now it's a money decree, my lord. Suit is based on unregistered partnership firm. And in 2019, before the filing of the suit, it got registered by himself. That's the position.
Learned advocate for the petitioner. Respondent wants to file objections. When?
Within 1 week.
In that view, stand over to.
Let him not execute the decree.
11th June.
We are not filed, till late, my lord, we have not filed any execution petition.
Who?
Due to summer vacation, only after, in the month of June, only we have filed.
Who will not?
Immediately after vacation, the matter may kindly be posted.
Who will not? We have kept it on, when it is kept? 20th June.
Great. The amount involved is more than 2 crores 42 lakhs, my lord. Immediately after vacation, second or third.
You can't have both. You are not seeking time, then we'll deal with it.
Till now, my lord, you have not filed any execution before the trial court, my lord. Till late, you have not filed any execution petition. Even though, my lord, you have filed execution petition, the notice has to go, and thereafter, my lord, kindly after second or third, my lord.
Is filed?
No, not yet filed, my lord.
Not filed, then.
Not yet filed.
Then simply 20.
Kindly after second or third of June, my lord.
Takes time to file objections.
Not only the oral assurance that he should not precipitate.
No.
It's a money decree. It's an unregistered firm. Suit is not maintainable.
So kindly have to take up the matter on Monday itself.
All cash transactions prohibited by
ready to address the arguments on
Income
Monday.
Tax Act.
Ready to address the argument on Monday.
Normally, if you make a statement, he will accept. Then you have to reciprocate. He makes a statement, you accept.
But whatever your lordship gives us the date, my lord, I am
20th.
ready. Any date, my lord.
20th June.
Please. You should not precipitate that. See only assurance.
Till date, I have not filed execution petition, my lord.
They have not filed execution. If it they file.
Great.
Number 24, to say Jayasima.
Shall appeal under section 37 of the Arbitration Act.
37.
37 of the Arbitration Act. Section 34 of the Arbitration Act, my lord, which I filed, came to be rejected, against which I moved this appeal. Miros, can I give background to your lordship court? In the first round.
Where is the order?
Yes, Miros. The order, Miros, is page 1, immediately after the appeal memo. 29th March 25. Page 100, I'm sorry. Page 100. My apologies to your lordships. Page 161, Miros, is the operative portion of the order, by which 34 application filed by me is dismissed by the trial court. May I give some background to your lordship court, which may assist the honorable court?
What is the main ground?
Yes, my lords. The main ground, my lords, can I just give 2 minutes of your lordship court with some 2 minutes background only. My lords, I'm a company which manufactures ammunition for the Indian Army. And I also provide software to all the 3 wings of Indian Defense. Now, my lords, I also supply equipment under the Government of India license to various countries and abroad. My friend's client approached saying that, look, I have an expertise with foreign companies which would procure this material from you. I can improvise your business, provide you software, provide you technology, etc., etc. You provide for giving me consultancy services. Contract is done in 2014. As per the contract, my friend's client had to give us A, B, C, three things. It's my case, it is not done. The contracts provides that if I am not satisfied, then I will not pay you fees. I'll not pay you fees, my lords, and the fees paid by me already, you have to return. My lords, my friend invokes arbitration. It was terminated, not challenged. Termination is not challenged. However, issue is framed. The arbitrator holds that termination is bad, and my lords, compensation is awarded. I go to section 34 court. 34 court stays the award without any condition. Thereafter dismissed. First round, my lords. Dismissed, I went to the appellate court. State. Other side goes to Supreme Court. Almost Supreme Court reject the SLP against the stay granted by your lordship bench. In the interganum, my friend moves an application that sir stays there. Yes. No. On my previous bench. I'm sorry. They moved an application that, notwithstanding the stay, required them to deposit the entire amount of the award before this court. Honorable High Court made the order of deposit. I go to Supreme Court. The Supreme Court set aside not just the order of the High Court, even 34 order, by saying this order is not right, go back to 34 court. And the matter went to 34 court, and that's where I'm come back to your lordship court. So in the first round, up to Supreme Court, there has been complete stay in my favor. Essentially because of the reason that the contract only says you have to give the services. If they are not satisfied, I have the option to say no to your services. And if you're taking money from me, you give the money back to me. I have right to terminate the contract. If I terminate the contract, you cannot make any claim of any losses or damages against me is the clause in the contract. But this is the background. If I can show you lordship code, the clauses of the
34 is limited. This is transplanted to 36.
That's it.
We'll hear it finally.
Very well, sir. My lords.
No difficulty.
Or learned advocate Mr. Senior advocate Mr. So-and-so, assisted by learned advocate so-and-so for the appellant to appear on caveat.
On caveat.
And learned,
Yes,
learned senior advocate Mr. Dhananjay
Joshi
with learned advocate so-and-so. The appeal the present appeal under section 37 of the Arbitration and Conciliation Act. Directed against judgment and order dated. Which is the date?
29 March 2025.
29th March 2025, passed by learned 85th Additional City Civil Instances, Bengaluru, in commercial arbitration petition.
It is known as yes.
24 of 25, whereby the application filed by the applicant appellant under section 34 of the Arbitration Act 1996 to set aside the award of the sole arbitrator came to be dismissed. First of having heard learned counsels for the parties and having prima facie gone through the subject matter controversy as well as the judgment of impugned judgment, the appeal deserves to be heard finally. Paragraph accordingly, appeal is admitted. Paragraph, it shall be listed when.
My lord's lordship may consider subject to my lord convenience and lordship convenience. Second week of June if suits your lordship court. Second week, third week. Third week lordship may consider if possible.
8 July.
That suits you, my lords. Much obliged.
Grateful.
My lords, they filed execution.
I have.
It was coming up on 29th.
Deposit.
No, deposit. The courts have set aside the orders. Supreme Court set aside the order. In fact,
if they want to
deposit
stay, I have no difficulty with it. The law is settled on that point, and my lord is familiar with the position of law also. Let them deposit. The claim today outstanding is about 25 crores.
This very proceedings between the same parties, your lordship were pleased to the 34 order stayed by the tribunal.
But what is
Supreme Court set aside the order.
What is the ground with you?
My submission to
limited ground available.
I tell my lord, I'll answer straight away. It's a complete perversity in as much as the award is made beyond the terms of the contract. Contract says I can terminate it And the contract says, you can't claim against me upon my termination. This is the contract. The court goes beyond it and says termination is illegal, not challenged, yet he says illegal, and then pay the money.
What is the award?
No, the award is for approximate, the award is for him to pay compensation to me. The award page, my lord, I'll point out. It's at page 194. 194. (2017), my lord, I have not yet seen any amount coming to me.
All throughout, there has been stay by
No, that is
honorable.
not, that is.
I can give the
did not
dates.
interrupt my
I can
learned
give
friend
the
at that
dates.
time,
I have judgment of the
but
Supreme
my-
Court on record of your lordship's court.
Not all my claims are allowed, only some of my claims are allowed.
And there has been absolute stay is what Supreme Court records in the order which I placed on record of your lordship.
Factually incorrect.
I can show the order, sir. I'm sure can't be said to be factually incorrect.
It's a money decree, it's a money award. If the appellant seeks a stay, he must deposit.
They are not seeking stay.
Then it's all right.
Seeking stay.
Our execution
I wanted
proceedings
execution may
anyway
be
go slow,
adjourned,
my
my
lord.
lords. Today, my lords, I mentioned to your lordship court, it got adjourned.
Our execution
Can be
proceedings
adjourned, my
anyway
lords.
go slow. So
Can be adjourned. It's coming up on 29, can be kept after my lord's date of 8th of July, my lord. That's all I'm requesting.
deposit some.
No, my lord, that's,
Will keep the appeal earlier.
Lord, it does not happen, my lord. Then my lords are also busy. Then it gets adjourned. Then sometimes my learned friend may not be available. It gets adjourned.
my lords, I'll come or somebody else will appear from my side. I won't seek adjournment from this side. Somebody will be here on the next date before the honorable court.
This
If
is
I'm
in
not
section
there as a
37.
counsel, somebody will appear before your lordship's court. I assure you.
The grounds attack every line of the award, every line in section 34, 68 pages of grounds, only questioning the reinterpretation of the contract.
The same
Not even
award,
permissible.
same award. And Supreme Court set aside the condition. My friend, the lordship court the correct
That is
facts.
not correct.
Look at the order. Why do you say it's not correct? I really fail to understand.
It is not.
But lordship, you see the order of the Supreme Court, it records this complete stay.
What is the relevance of that earlier order?
Because same award, same award,
Same award.
same award. This is second round. But same award.
What happened to the Supreme Court process?
Supreme Court set aside section 34 order. Sir, please allow me now. Please. Sir, can I just give 2 minutes of your lordship's court? Same award paid by civil court. Civil court dismissed 34. Matter comes to Honorable High Court.
So this is second round.
Second round. In the first round, I'm saying. Second round, the matter comes to your lordship court in 37. Honorable High Court stays the order completely. Supreme Court does not entertain the SLP.
But even the correct narration of facts.
My friend may not interrupt, please. Don't
But
interrupt.
the correct
If not
narration
seen the
of
order,
facts.
my lords, can I just show the order?
Correct, sir.
My friend has not seen the order, unfortunately.
From this year and.
My lords, he should see the order. But 37, Honorable High Court granted complete stay, which my friend challenged in Supreme Court by SLP. SLP dismissed.
Remand.
Then dismissed. So matter was pending for the court by interim order. The court granted stay. They went against interim order Supreme Court, saying that this is a stay without condition. Supreme Court rejected the SLP, saying you make an application. So they moved your lordship court. The Honorable High Court in the second round, pending this appeal, said that say now is modified to the condition I must deposit the entire amount. That order I challenged in Supreme Court. Supreme Court set aside the order of the Honorable High Court by consent of my friend client, and not only the order of the High Court, even 34 order is set aside. And Supreme Court remanded back not to High Court, to the trial court by the order. So look at the importance.
Again, same award.
Again, same order.
Same award.
But similar.
Same award.
Same award, sir. Same award. So please consider, in the first round, speaking orders of the High Court and Supreme Court, speaking order, not just one line order, set aside order of deposit, complete stay. First round, Supreme Court says 34 order by the trial court is bad. By consent, set aside. By consent, set aside. Matter goes back to 34 court again in the second round. And unfortunately, the court, again, with all respect, holds against me like it did in the last time. So I'm before the court in the second round. But kindly consider, from date of the award until this stage, there has been complete stay without condition. Without condition. And the condition imposed by the High Court is reversed by Supreme Court in this very matter.
Now I'll explain. Award came to be passed. The first round of Section 34, the Section 34 court did not, according to the Contempt Supreme Court, did not apply its mind in entirety. Merely said that the award is right. I find no reason to interfere because after having perused the award. That my learned friends had groused with, saying that, look, Section 34 has not applied its mind. So when in the Section 37 court, the court imposed a condition for deposit of stay, the matter went up to the Supreme Court. The Supreme Court said, forget the stay or anything. The Section 34 decision itself does not seem to be right because the court has not applied its mind. You go back to Section 34 court.
These are exactly
But the fact is that there was no unconditional stay. There was no order at that point of time. The moment the order of stay came,
the council is trying to submit that this is not only a second round of litigation.
It is.
But it is a litigation in repeat in a way.
That's right.
So the merits in some way or other way of the award and about the requirement of deposit amount was tested in the early round. And the test went up to Supreme Court and the Supreme Court did not direct.
There I beg to differ. There I beg to differ.
That's the order of
Sum and substance of his
his submissions, which is why I interrupted him.
In any way, he is not seeking stay.
Fair.
And the appeal is pending. So we can prepone it to 1st of July.
No difficulty.
And
let not anything be said. We will see. Let not anything be said.
My friend should agree with or fairness to him.
My lord has seen my conduct.
I have to say nothing beyond.
If nothing happens in the first week of July, then we will come and inform your lordships.
Very well.
That we are.
Because I respectfully agree.
Then we'll see it.
Lordship pleases. Much obliged.
So, is respectable.
No, I respect, my lords. Any member of the bar, and my friend is very senior. I know, my lords. Very respectfully.
Everybody is respectable.
No, I also too respect, my lords.
How do we exclude you?
I'm grateful, my lords.
1st April, 1st July.
Much obliged. Grateful to your lordship. Immensely obliged. Lordship, please.
Number 25. Mr. Gautam Sridhar.
May it please your lordships. My lords, this matter pertains, it's a PIL by a farmer's body. My lords, the relief sought in this matter is, my lords, to keep the procurement centers open for 365 days, my lords. Today, my lords, the procurement centers, my lords, are opened for certain periods during the Kharif and Rabi seasons. Now, my lords, pleadings are complete in this matter. The issue in this would be, my lords, I would actually be treading a very thin line between a policy decision and, my lords, an Article 21 right juxtaposed with the fundamental duties. Now, my lords, it is my case, my lords, that keeping open the procurement centers on a 365-day basis would not in any way, my lords, impact the policy decision per se. The reason would be this, my lords. The price, the MSP, my lords, the minimum support price for about 22 crops is fixed by the central government every year, my lords, for the Kharif marketing season and the Rabi marketing season. Now, my lords, these prices, there is a revision once a year. Each time the prices are revised, procurement centers have to purchase at these particular prices. Today, my lords, my limited prayer in this matter is to keep these procurement centers open on a 365-day basis. Now, my lords, I would in fact be placing reliance on their statement of objections. Most of my relief would be vis-a-vis the state government. I'm really not claiming anything so far as the union government, because the procurement centers, Karnataka is a decentralized state, and the procurement centers are managed by the state government. Now, my lords, if I may request my lords to kindly have the statement of objections filed by the state. My lords, in the statement of objections filed by the state, there is a very categorical admission by the state saying that, yes, we do appreciate the fact that due to the vagaries of nature, now the seasonal patterns have changed considerably. Now, my lords, the seasonal patterns having changed, the production patterns, the harvest seasons also change. So today, my lords, what happens is if a farmer produces certain goods, that would go beyond the period sometimes when the procurement centers are kept open. If I may request my lords to kindly have para 12 for a moment of the state's counter.
They are saying that this is seasonal activity. Therefore, every day for whole year keeping the procurement center.
My lords, that
feasible nor practicable.
My lords, that
it might
is.
entail the financial burden also.
My lords, I'll just answer that, my lords. If my lords may kindly have para 12 for a moment.
Para 12. Of at which page?
Of the state's counter.
Objection dated.
My lords, that would be the objections state's counter, my lords.
Para 12. Yes.
It is submitted that usually all major crops are seasonal, and accordingly the government of India, the respective state, my lords, has that, and the respective state governments implement the MSP operations during the harvest season only. The procurement period is fixed for 3 months in each season by the government of India. Due to change in climatic conditions, the traditional Rabi and Kharif season have itself undergone a considerable change. And if agricultural produce is available for sale throughout the year, then this should be a subject dealt with at the suitable levels in the government of India, and government in India is to frame MSP policy accordingly. My lords, there is no policy of the government of India, my lords, with a certain sense of responsibility, I could say this after doing some research, that prevents an MSP from being open or a procurement center from being open 365 days. This is a categorical admission. This is a problem of the change in patterns of agriculture, my lords. Now, my lords, if I may request my lords to kindly have this one chart, madam. Give that a second. My lords should kindly see this first page. My lords, the central government fixes a MSP. My lords, this MSP changes year on year. My lords, I am not seeking any alteration. This, my lords, is a very scientific methodology which is adopted by a commission. There is a permanent commission. There is a methodology which is adopted, and these prices are fixed per crop. Today, my lords, I am not seeking any change in this. All I am seeking is, today, if a farmer takes his produce, this price should be available to him throughout the year. Now, my lords, a Kharif marketing season is available for a period of 1 year. My lords may kindly note, a Kharif to September. And the marketing season, my lords, as per the government of India itself, is from 1st October to the 30th September. It is one complete year. The marketing season is considered as one complete year. Now, my lords, the Rabi marketing season is from April to March. Again, it is one complete year, my lords. The seasons being one full year, my lords, the benefit of this price is not available for the full year. Now, my lords, taking the example of Karnataka. Karnataka is a decentralized state. My lords, there are two methods in which a farmer could probably give his produce. One is, my lords, through the APMC route, that is the Agricultural Marketing Society. There, my lords, it is through, my lords, there it is through process of traders. There, the concept of MSP would not apply. It is only in these procurement centers, my lords, the MSP which is fixed by the union government would apply. I am seeking, my lords, this be made applicable throughout the year. This, my lords, is a corresponding right under the 21, read with the directive principles. My lords, may I just place the directive principles? 21 I will not be placing, my lords. If I may just place these directive principles, my lords. That is 38 to 39 and 48. Only these three directive principles, if I may place. My lords, now 38(2) says my lords, income and endeavor to eliminate inequalities in states. My lords, this would be a case, my lords, where the facility and opportunity. 38(2). My lords, again 39, my lords, may kindly note 39A. It says, shall have an adequate means to livelihood. Also kindly see 48. 48. The state shall in 38(2), my lord says, the state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities and opportunities, not only amongst individuals, but also amongst groups of people residing in different areas or engaged in different vocations. Now, my lords may kindly have 39A. The state shall in particular direct its policy towards securing that the citizens, men and women, have a right to an adequate means of livelihood. This would directly flow from 21. Now, if I may request my lords to have 48. The state shall endeavor to organize agriculture and animal husbandry on modern and scientific lines, and shall in particular take steps for preserving and improving the breeds and prohibiting slaughter. So and so, we are not really concerned with that. Now, my lords, the prices, the MSP prices in the chart that I handed over to my lords is fixed by the Commission for Agriculture Costs and Price Committee. This is a permanent commission, my lords, which fixes the price every year. And these prices my lords, that is fixed by the permanent commission, is finally sent to the cabinet, and the cabinet approves this for every year. Now, my lords, the definitions of procurement center and central pool, my lords, have really not been defined in the Act. But if I may only request my lords to kindly have the Food Security Act for a moment. My lords, I'm trying to draw an analogy. There is a corresponding, my lords. The entire purpose of this procurement is so that there is equal distribution under the TDPS system. Now, my lords, I will really not trouble my lords with the definitions, but my lords will only mark the definitions. Section 2.2 deals with central pool. I won't really read it. 2.2 deals with central pool. 2.10 deals with MSP. What is the minimum support price? There's no dispute so far as these provisions are concerned. Now, I may request my lords to kindly have 22, section 22. The central government to allocate required quality of food grains from the central pool to the state governments. The central government shall, for ensuring the regular supply of food grains to persons belonging to eligible households, allocate from the central pool the required quantity of food grains to the state governments under the targeted public distribution system as per the entitlement under section 3 at prices specified in schedule 1. My lords may then kindly skip section 2 and 3. Subsections 2 and 3 may be skipped. My lords may kindly have subsection 4. Without prejudice to subsection 1, the central government shall procure food grains from the central pool through its own agencies and the state governments and their agencies. 24. Implementation and monitoring of schemes for ensuring food security. The state government shall be responsible for implementation and monitoring of the schemes of various ministries, so and so. Now, my lords, this may be read with schedule 3, my lords, schedule 3, which is at appended to this act, page 21 of this act, my lord, schedule 3, the provisions for advancing food security. My lord, you kindly see there 2 procurement, storage, movement related interventions. My lords, the point that I'm trying to make, my lords, this is beneficial in both ways. This is not adversarial in its sense. My lords, 48 says that agriculture has to be promoted. Article 48. 47, my lords, says that there is an equal directive principle to ensure nutritional food is available. Now, my lords, the central pool takes food grains, my lords, which is supplied, if it is supplied throughout the year, it would also be available, my lords, under the Food Security Act throughout the year. A corresponding duty, which is the Act, my lords, the Food Security Act is a fallout of Article 47 itself. Now, my lords, coming back to the state of Karnataka. My lords, the state of Karnataka today, my lords, has about 31 districts. We have about 236 taluks and about 745 hoblis. My lords, the state in its counter at para.
No, we are just thinking about 48 and 39. They're all directive principles of state.
I do understand, my lords, it's a
Directly
policy decision, and
Not directly enforceable.
I do understand where I stand, my lords. I know I'm on a.
I may look anywhere, but I'm listening to your argument. You don't know.
I do understand. I'm treading on a very thin line, my lords. That it's more a policy decision, and I
to look at you only while you argue. That can't be.
Well, it's not fair to take up too much time during the end of term because others would be.
We have not used all your imaginations. We have not said anything. We have not thought anything. We have not curtailed you in any way. Yes.
Well, then the onus becomes more on us not to extend, my lords, when your lordships don't tell us anything.
No. If you don't have the faith in the very pleasant way in the court, then don't argue. It's a very pleasant way to express no confidence in the court. That you are not looking at me while arguing. We are not supposed to look at distrust to the court.
No, my lords, that's not my thing, my lords. I don't
want to argue. Don't argue.
No, my lords. I'm only requesting if my lords may kindly have.
We are not supposed to be controlled in our moment by your perception.
No, that's not at all my intention. Not at all my intention, my lords. My apologies. Not at all my intention. My lords, may I request my lords to have the objections of the state, my lords. My lords, in the objections of the state, my lords, para 14. My lords, it is submitted that the procurement centers are opened at the hobli level, considering the demand for procurement in the villages of that particular hobli. Number of procurement centers are planned and scheduled by the district. The task force committee headed by hence the question of non-availability of procurement centers also do not arise. My lords, they do specifically state that, my lords, the procurement centers are opened at hobli levels. Today, my lords, they say it is a policy decision and the main ground, my lords, of the state to say why this misuse. Now, my lords, may kindly say why the state mainly opposes. 2 more paras from this objection and I will not go further, my lords. My lords, may kindly have page 3.
Yes.
The state, therefore, my lords, about 4 lines from the top of page 3. The state, therefore, opens sufficient procurement centers from the beginning of the procurement period till the end of the period. In the absence of the state cannot operationalize the procurement centers throughout the year and enable the farmers to sell their produce at minimum support price. My lords, it would be my respectful submission, my lords, there is no restriction imposed by the union government saying that you cannot keep the procurement centers open throughout the year. Now, my lords, I request my lords to have para 5, about 6 lines from the bottom.
Paragraph
5, my lords, same page, about 6 lines from the bottom.
Yes.
If the market prices are more than the MSP, farmers are free to sell their produce in open market and get the profit. So my lords, this is even what is said by the union in the affidavit. It is said by the state. It is not a compulsion on the farmer to sell it at the MSP. If the farmer is getting a better price outside, he is free to sell it outside. But now, my lords, kindly see this. Usually all major crops are seasonal, and accordingly, the government of India and the respective state governments implement the MSP operations during the harvest season only. Usually procurement period is fixed for 3 months in each season. Vis-a-vis, my lords, it is also noticed that whenever MSP centers are opened during the peak harvest period, market prices also improve as per MSP. Now, my lords, in para 12, my lords saw that they admit there is a seasonal change. Now, my lords, they also admit if the procurement centers are open, my lords, the farmer benefits. Now, kindly see the main reason why they say it should not be open.
Yes.
Now, my lord, 6. This is their entire objections revolves around para 6. It is submitted that, my lords, para 6, my lords. It is submitted that if MSP centers are kept throughout the year or during off season, there may be serious misuse of MSP operation by traders. The traders may procure produce from farmers at a lower price during the peak harvesting period and try to sell it at MSP during the off season, thus denying MSP benefit meant for farmers only. Now, my lords, under the MSP scheme, my lords, traders don't have a role, my lords. It is only a farmer who is registered who can sell produce at under the price support scheme. So, my lords, a trader has absolutely no role in this. My lords, the question of traders would come under the APMC Act, my lords. There, what happens under the APMC Act, traders would play the role of middlemen. Here, my lords, the state itself admits, yes, keeping the MSPs open, the procurement centers open benefits the farmer. Further, in para 12, they admit that the seasonal changes are there. Therefore, it is an issue which you have to take up with the Union of India. My lords, the Union of India nowhere prohibits, my lords, keeping the procurement centers open at all.
Nowhere prohibits opening of more centers.
My lords, I'm not on the additional centers, my lords. That would actually fall.
365.
Now, my lords, for the purpose of completion, if I may just point out to the union's counter, my lords. If I may request my lords to have the union's counter. Para 4, my lords, at page 2. My lords, about 5 lines from the bottom. The objective of food grain procurement by the government agencies is to ensure.
Reading react. Objects and reasons.
My lords, no, my lords, objections of the union. Objections of the central government, my lords. Counter affidavit of respondent 1.
Number 1. Yes.
My lords, about 5 lines from the bottom, page 2, my lords, internal page 2. The objectives of food grain procurement by the government agencies is to ensure that farmers get remunerative price for their produce and do not have to resort to distress sale. And the aim is to service the, my lords, this is very crucial, my lords, the aim is to service the Food Security Act and other welfare schemes. Now, my lords, the Food Security Act says expand procurement centers, have procurement centers open. So that, my lords, it directly augments the TDPS system, my lords, the targeted distribution system. Now, my lords, over the page, there is the decentralized scheme. Under this scheme, The state, my lords, second line, page 4, under this scheme, the state government itself undertakes the direct purchase of paddy or rice, wheat, and stores and distributes these food grains under the Food Security Act and other welfare schemes. The central government undertakes to meet the expenditure incurred by the state government on procurement operations as per the approved costing. The central government also monitors the quality of food grains procured under the scheme and reviews the arrangements made to ensure that procurement operations are carried out smoothly. Before the, my lords, this would be before the onset of each Kharif and Rabi season, procurement period government and FCI in the state, food secretary meetings, procurement period in each season is decided keeping in view the total sown area estimated so and so. Now, my lords, the main problem, my lords, that the union says, my lords, may kindly have para 5 at page 8. This is the main, my lords, the state's main contention is there would be misuse. The union's main contention is at para 5, opening of procurement centers, my lords, has that. Opening of procurement centers around the year can give scope for large sale recycling and misuse of MSP and procurement policy of the government of India. Union of India processes custom mill, right? Then, my lords, we are not concerned with that. The last objection is, my lords, they say there is an MOU with Karnataka. Now, the MOU, my lords, particularly pertains, that is given in page 6. I'll place that MOU. The MOU, my lords, is only specific to custom milled rice. And, my lords, even in the MOU, my lords, this MOU is entered season on season. There is no restriction, my lords, on the keeping open the procurement centers for a 365-day basis. My lords, it is in this regard, my lords, it would be our humble prayer that.
Yes, Mr. You are appearing for Union.
Please, Lords, I appeal.
Madam.
For R7, my lord, the warehouse corporation, I'm not contesting because we are not part of the procurement scheme anymore. They're only a storage center.
R7, who is R7?
Karnataka State Warehousing Corporation. It's only for storage.
Lords, in respect of first prayer, which is sought.
First condition is that don't complain if we don't look at it. We are not going to look at it. Till you are, yes. Yes.
Lords, there are totally two reliefs sought by the petitioner, Lords, against the state government mainly. Lords, one is that throughout the year, my lords, they want the procurement center to be open. Second is number of procurement centers, my lords. My lords, in respect of the second relief, my lords, at para 10, my lords, in our counter, we have clearly stated, my lords, election, it's for the state to decide and inform so that in turn we can make the payment scheme, my lords. In respect of the first relief, my lords, which is sought, for having the procurement center throughout the year, my lords may kindly see page number 5, para 5 for a moment, my lords. No, my lords, my learned friend read the first portion. The second portion also is important, my lords. Para 5, my lords. I will not read the first portion, my lords. Second portion from the last 3 lines, my lords. In order to achieve this dual goal, Union of India plans and complete the procurement in a time-bound manner so that the finances of every year can sustain the said scheme. Establishment of permanent procurement center terms and conditions of understanding signed between the center and the state of Karnataka, but will also derail the economic apparatus of the government of India and the FCI, which is moduled on the principle of seasonal procurement and the payment thereof. Lords, and in the act also, my lords, which is available at page 45, my lords, section 3 clearly state, my lords, that the central government shall at least 50 days before the beginning of every sowing season declare by notice, my lords. It can't be throughout the year because that aspect.
45 is actually not the act. That was the farmers' bill which never came into force. It was only for corroborating things, saying that there was the bill, my lords, proposed that there shall be procurement centers which would be run by this, never came into force. This was one of the 3 farmer bills which never came into force.
Yes, ma'am.
My lord, constitutes an more in the nature of interference, my lord, in a policy decision between the state and the central government.
Lord learned advocate, Mr. So and so for the petitioner. Learned.
Lords, for respondent number 1, my lords, Union of India.
Assistant Solicitor General.
Union of India.
He's not assistant.
CG, my lords.
solicitor.
Central Government Council, my lords. Please.
Central Government promote for Union of India, learned additional government, Nilofer Akhtar for state and authorities, and learned Miss
Urmila Pulat for R7.
Urmila for this one 7 at length. The councils for the respective parties stated that they argued the petition finally. They further stated that the pleadings are completed, no further are required to be added or supplemented. Resort to judgment.
Obliged.
Much.
This is number 26, the P. Usman.
So, direction has been sought, my lord, in this writ petition for payment of the compensation to the families of the person who died during the COVID, my lord. The people who are the employees of the
replies, right?
Malad, the Malad counsel for respondents 2 to 5 has to give a response, Malad, because it is their employees who have
Reply
died.
shall be
around
paid by
351 people died, my lord.
There is 2 to
There
5.
there is a direction, my lord, annexure A, there is a direction to pay compensation at the rate of rupees 30 lakhs, my lord,
For the
to
next
each families.
Earlier it was dealt with. No replies are filed so far. Shall be filed invariably without fail on or before next date, stand over to 10th of June.
Lord, the next matter, my lord, filing, my lord, in pleading application, lordships may have it, my lord, post vacations in the next matter, very next matter.
Serial number 92, please, my lord.
Post vacation.
Matter requires because Monday,
4th of July.
page 25, I request kind indulgence. Serial number 92, the matter pertains to an election which they were all disqualified and they approached this honorable court. This learned single judge directed the matter to be tried before the cooperative societies under 72, subclause 2. But what has happened is the order pertains to allowing the counting of the votes and also declaring it and keeping it in a separate box. It's on Monday, my lord. I request the matter to be taken up at 2:30 because serial number 92, it's 2:30 first matter, your lordship. I have to serve copy
28
also.
is also connected with 27, my lord. I'm so sorry. It may be connected because that.
Same date, 4/7, 28.1 also.
Lords, may I make one?
28.2 also.
My lords, serial number 29, my lords. I'm appearing for the petitioner. Some personal inconvenience in the afternoon, my lords. Kindly have this matter off for vacation, my lord.
7th July, as requested by learned petitioner.
Please, my lords.
Which one? 30. Yes.
I may be permitted to file objection under pending grant 2 weeks.
At the request of other side is no objection.
6, my lord.
At the joint request of learned of the parties, stand over to 9th of July.
My lord,
My lords.
66, my lord.
Application for substitute service, my lord. So, yeah.
50.
You have to file an application for
50 or 15. 15 or 50.
50.
So what is the request? Time.
I mean, permitted to file.
Let it PIL is there. What is this for what?
My lord, it's for demolition of the 4th and 5th floor of a building that has been constructed, my lord,
It can
by
wait.
BBMP.
It can wait.
Can we?
Learned advocate Ms. So-and-so prays for time to file reply. Stand over to 4th August.
Serial number 90, my lord. See, 90, number 90, kindly after vacation.
What do you want?
90, kindly after vacation.
After vacation. At the request.
66.
Serial
may
number
be after
1.
vacation, my lord.
Send over to 10th of July.
66 also after vacation, my lord.
Lord, serial number 1,
66
my
after
lords.
vacation.
66.
66. I'm the respondent.
66 after vacation.
After vacation, my lord.
17 July. As requested.
Lords, may I make one, sir? Serial number 1, my lords, by mistake a submission was made, SLP has been filed. Lords, it was in fact for serial number 2, my lords. BBMP is the contesting respondent in that.
Okay, we will re-notify tomorrow. We'll
Yep.
leave that part.
Please, please.
Anna, you'll hold
ಸರ್ ಇದು ಟೋಟಲ್ ಒನ್ನಿಂದ ವಿ ಸಿ ಇರೋರಿಗೆ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್ ಟೋಟಲ್ ಒನ್ನಿಂದ? ಹಲೋ,
ಕೇಳಿಸ್ತದೆ ಸರ್.
ಸಿಟ್ಟಿಂಗ್ ಅರೌಂಡ್ 3:30 ವರೆಗೂ ಆಗುತ್ತೆ ಮೇಡಮ್.
3:30
ಇದ್ರೆ ಹೇಳ್ಬಿಡಿ.
ಓಕೆ ಸರ್.
ಹಾ 3:30 ಲಾಗಿನ್ ಆಗಿ ತೊಂದರೆ ಇಲ್ಲ.
ಓಕೆ ಸರ್. ಯಸ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಓಕೆ ಮೇಡಮ್.
With the kind permission, my lords, matter at serial number 54 may kindly be taken while your lordships raised from the bench. There is some urgency in the matter. Matter at serial number 54.
We'll try to take up. PIL.
Yes, my lord.
We'll see if time permits. Let us see.
May I request to read it by 4:30 at least?
What is that urgency?
My lord, in fact, the land belonged to the whole village, and some fraud, by playing fraud by on the court, there's some awards have been passed by the local adalat. Based on that, sell-its have been created, third-party rights are being created, and the land is awarded with a compensation of some crores, and that they are taking the particular money and has sought interim direction, directing the SLO not to disperse the amount until the disposable litigation. That is the only urgency.
Lord, the order of 2014 of the Lok Adalat is now seeking
The,
for certain.
no, no, the transactions are of recent years.
We'll see.
Please.
Well, at serial number 39, may I seek for a short accommodation, my lord?
39.
We want to engage a senior counsel in that.
After vacation.
A date may be fixed, my lord.
26th of June.
Much.
As requested. Forty-three. 43, yes.
Date may be fixed.
27 June.
Thirty.
How much? To which material it is? Then go serial wise. First 230 serial wise. Serial number.
Seal number 95.
92 Allah.
So 230 matter.
Complaints of my lord, the direction, I'm producing the RTC. They have restored the entries.
Pursuant to order dated 23/4/25. Learned additional witness.
Please.
Mr. So-and-so produces memo dated 2/5/25 along with the copies of the revenue records, which reflects that that in respect of land survey number 62 of Madda Nanga Taluka at measuring 32 acres and 4 guttras of the mutation register is amended to insert the name of the petitioner in compliance with the order of learned single judge. Full stop. The mutation register extract is produced. Full stop. Learned additional original paragraph. Our submitted that the proceedings in nature of review. Review or SLB.
My lord, we have initiated proceeding before the Karnataka Appellant Tribunal.
Bring before the Karnataka
Appellant Tribunal
Appellate Tribunal.
in 481 of 2024.
Instituted, which is application number 481 of 2024.
Please.
Which is stated to be in relation to the subject matter.
Please.
Education. Full stop. In view of the fact that the said proceedings are filed, it goes without saying that if any order is passed by the competent court, the entry shall abide by the
Now, in the KT order proceedings, that's 481. The order, the proceedings of KT has been stayed by this honorable court. If I
We
may
have
request,
filed appropriate
that is
application.
okay. That may be recorded. May
Responding to this, learned advocate stated that the proceedings before the KIT in application of 481 of 24 has been stayed by this
Yes,
court
in WP number, that's
read petition number
2309 of 2025.
Appropriate application for vacating also. My lord, the respond number 2 and 3 are present before the court. Respond number 1 and 2, my lord, are present before this honorable court. Their appearance.
It was also stated that in light of the order passed on the last occasion, comma, respond number 2 and 3.
1 and 2, my lord.
1 and
Sorry.
2 are personally present in the court. The presence is noted and henceforth dispensed with.
Please.
Present is not noted and dispensed with.
Please.
That's great.
Obliged.
So pass over matter, still number 11, Mr. Vishwanath.
Appealing for respond number 4 in this matter. I pay for some time to file my statement of objections, my lord.
Mr. Vishwanath.
Respond
PAL.
number 4, my lord. Appealing for respond number 4. Pay for some time to file my statement of objections.
Learned advocate for the petitioner is not present. Full stop. The order passed on the paragraph passed on 7/4/24 reads as under. Full stop. There is a non-compliance of the order. Full stop. The compliance of the aspects directed is essential to the very filing of public interest litigation and the locus standi of the petitioner. In that view, if the order dated 7/4/25 is not complied with, and the necessary documents are not produced, necessary papers are not produced, showing the memorandum of association and the objects of the petitioner association, within 4 weeks from today, the petition shall stand automatically dismissed on the ground that the petitioner is not able to, nor willing to satisfy the court about its locus standi and the bona fides as a public interest petition.
Still number 31, Mr. Ganpati Bhatt.
This can go after vacation,
Please.
13th of June.
Still number 32.
Can go after vacation.
My lord, it's a very simple one, my lord, wherein, my lord, I have been issued with, I have been granted with a license, my lord.
Granted.
With a mining license, my lord, in 2006 for the limestone, and subsequently even I applied for the dolomite also, my lord, wherein they have been given, and it is for the period of 20 years, my lord.
40 years of time.
My lord, section 22D is very clear, my lord, that it has been rejected under section 22D of
My lord, the extent of land.
mineral
that,
concession rules.
The extent of land that was required was 4 hectares. My lord, but they have only 6 acres, which is 2.5 hectares. Because of which, my lord, they are not entitled for a grant of a license as per rule 22D of the MMRDA.
My lord, there is a proviso to the section 22D, my lord. It is very clear. That is, C is there, my lord, that is 4 hectares in respect of all mineral deposits other than those specified under clause A and B. To that, there is a proviso, my lord.
19 comes up away.
Whether in the facts of the case, the petitioner is entitled to the benefit of the contemplation of proviso to rule 22D of the mineral concession rule.
It is not applicable for the renewals, my lord. Because its proviso is very clear, my lord.
And whether the proviso is not, whether the proviso is applicable or not.
My lord.
As argued by learned advocate of the petitioner, would require a reply from the respondent.
My lord,
My
please
lord,
see the
my
prayer,
lord, my lord.
My lord, may
My lord,
see
if the court
prayer.
permits, I would like to make a submission, my lord. There is a series of M series, my lord, the document which I have produced before this honorable court, my lord, wherein the same respondent number 1, my lord,
Rear
has
itself is
extended
not
for,
maintainable.
30 years, my lord, though
on
they are less
parity,
than
my
the 4
lord.
hectares. They already issued the license, my lord. They already extended the license, which has been mentioned at annexure M, my lord.
So what is the problem now? What is the problem if license is issued? If license is already issued, what is the problem now?
My lord, for them also it is less than 4 hectares, my lord. For them, they have issued, extended the license, my lord.
So now what is the prayer?
My prayer is
And
I may be also be permitted to extend my, the direction may be given to the respond number 1 to extend my license also, my lord. As per section
My lord,
88.
mandamus is sought, my lord. My lord may see the prayer.
Proviso says that for renewal this will not apply.
Very well, I'll justify it, my lord. My lord may have this on the 5th.
My lord, even they themselves have extended the license, my lord.
My lord, if
Though
there
it is less
on
than 4
parity,
hectares.
if he is
From
entitled
the
to.
respondent, continue. The reply shall be filed on the next day, put up on 6th of June,
Obliged.
immediately after.
My lord, they have already extended for other people, my lord, of the same place, my lord, who are also situated in Mudhol, my lord.
Let us
For
have
them,
the-
they have extended for 50 years, my lord.
Let us have the reply. The question of 4 weeks only. Let us see. Yes, next.
Number 33, Mr. Prashant F. Goda.
This can wait.
My lords, this
This
is a
can
case,
wait after it.
my lords, this is a case, my lords, on the last occasion also, they said they would be taking instructions. My lords, this is a case where, my lords, the order has been set aside by the appellate authority, revisional authority. And despite that, my lords, there is a fresh demand. Only 2 pages, my lords. My lords may kindly see page 224.
Reply is filed.
My lord,
My lord,
I haven't received reply from respondent number.
Shall
In
be
the
filed
meantime,
over
no
the next
precipitative action, my lords.
18th of June.
My lords, in the meantime, no precipitative action, my lords, because my lords may only see 1 page, my lords, only 1 page.
You move the vacation, judge, if any precipitate action is taken. Yes,
34, Mr. L.M. Chidanandaya.
this can wait.
Yes, my lord.
Your matter can always wait. Yes.
Lordships, the only
10 down to
reason is
20.
government, it has to be remanded, your lordships. That's all I'm saying. Matter needs to be
My
remanded, your
lord,
lordships.
even for that, I have to get consent from the
20
secretary, my lord.
20th June.
Obliged.
Lordships are at least a little dates, first week, your lordships, because it's only, I've sought my consideration. If it is given to third parties, the area will be given. That's the reason, your lordships. 10th or 12th of June, your lordships. A little earlier date.
12th of June.
Much obliged.
35 is urgent. Number 36, Mr. Ravindra Gajan Kulle.
26th of June.
36. Number 37, Mr. Chandra Tariga.
27th of June.
38, 39 are urgent. Number 40, Mr. Abhishek. 40.
So there is a contempt also filed, my lords. They're seeking for the stay of a single judge order. My lords, it is with respect to a pension, my lords. Depending on the syndicate decision, my lords, the order is at page number 25. The direction, my lords, at page number 36, my lords, can be seen. My lords, the internal communication given, my lords, from the finance officer to the registrar has been challenged, my lords. On that direction has been issued. The state has also.
After it.
State has also filed an appeal, my lord. State has also filed appeal in respect
Lord,
of the
one-
same
one-
impugned order.
Let them pay as per the new pension policy.
Nothing, no.
No, I'm not getting any pension.
We'll see. 13th of June.
No, in fact, my lord, I'm in dire state of,
But they have filed appeal.
no, that appeal only I'm saying. The appeal says that I'm under the new pension policy, not under the old pension policy. So let them pay as per the new pension policy only.
Yes, Mr.
That's for the
They say
university.
You will pay as per new pension.
My lord,
And
I'll
the-
take instructions, my lord. I'll secure instructions. This university's order has been challenged, my lord, here. That has been
Find
set
out.
aside. I'll
No,
find
they-
out, my lord. And
they
by
say, my
next
lord.
date of hearing, I'll make my submission.
They say, my lord, that I am under the new pension policy, not under the old pension
But
policy.
you are getting as per the new.
No, I'm not getting
Why-
anything.
why
They
you are
are
not
saying I'll
getting-
neither pay you this nor this.
Why you are not waiting?
Why they are not paying is, my lord, I was under the old pension policy and that was not allowed. They say you come under the new pension policy, returned all my contributions. saying that we will not pay you. They brought me into old pension policy, returned all my contributions from new pension policy, neither paying that nor paying this.
You are for one of the respondent.
Yes, my lord. The employee. Not one penny is paid, my lord.
My lord, sir.
Not one penny is paid.
He gave a representation stating that, my lords, not under the new pension
Why
scheme.
they are now saying what you are ready to pay?
My lords,
You pay under whatever policy you want. That's what I'm.
Subject to outcome of the appeal.
my lords, sir. The problem was, my
You
lords,
can't have both.
he gave a representation. The syndicate, my lords, which has taken a decision, didn't have a power itself.
I agree.
Now dispute is whether he is entitled to hold or not. You
Please.
say new will pay you as per the new scheme.
That's all I'm
new
saying.
scheme. So then as an interim arrangement, he wants to be
That's
paid as
what
per
I'm-
the news.
Yes.
What is wrong in it?
Let that be recorded, my lords. I'll
Huh.
seek instruction because, my lords, this
Seek instruction.
Let
Let
that
that
be
be
recorded, my
recorded.
lords, so
No,
that I
tomorrow
can-
they'll come and say all this will be.
it's undertaking, my lords. Now, my lords, the problem is there is no contribution.
Your stand is that
Yes.
Please, my lords, honor.
No, they should.
230.
That's the
on
only problem is,
28.
my lord.
Sorry.
238 on 28.
Please.
Find out.
Please.
Or we'll pass the orders.
Let
Better
that.
you give concession.
Sorry.
Concession means better you agree because it is your stand, page 21.
35.
Go to page 21.
Please, my lords.
Your memo of appeal.
But the only difficulty now occurs, my lords, because he has given a representation. The contribution what has been given, my lords, has been taken back.
I paid the contribution. They forcibly, Lord, return back. And now they are saying, I will neither pay you under this nor pay you under this.
Under this, you have to pay them under the old scheme. Huh?
You have given back the contribution.
Yes, they took back. They said, my lord, that I come under the old pension policy and your contributions under the new pension policy are returned to you. Take it back. We will pay you as per the old pension policy. I bow down.
Monday take.
Grateful.
Whether he wants to be paid under new policy. It's an interim arrangement.
He wants my lord under the old scheme. New pension
No, no.
scheme, they're not different.
Interim arrangement.
Interim arrangement.
That's what.
Subject to outcome of the appeal.
Obliged.
Because he is not getting anything.
Yes.
That is
Lordship may observe that, my lord, because
That's all.
I have,
My
my
lord,
lord,
I've
almost
never
one
said,
note.
my lord, ultimately he has to get something. It's not that, my lord.
That's what. Whatever they are
Please, my
ready
lord,
to
please.
pay.
It's not fair on my part to say. He shall
Instead
not.
of adjourning it, I'm only saying, Lord, let this be record. Whatever they are ready to pay, let them pay it provisionally. I bow down. Then I
Please,
will
my lord.
not ask anything. Let the.
Why should we record? We are saying that we are asking them
Yes.
to one of the most fair advocate.
Yes.
Not dispute.
Yes.
Please.
Great.
Number 41, Mr. Srikanth MP.
Lords, the review, my lords, is about the sports quota government seat, my lords. I made a submission on the other day. That, my lords, for third year, my lords, I'm told that, my lord, there are seats available in a few, my lord, colleges. I can be accommodated there. What this court has recognized is my entitlement as, my lords, number one in the list, and also awarded compensation.
Yes, anything you want to submit? Last time the council made certain.
But as far as shifting him to another college is concerned, that is no longer permissible, because by virtue of the fact that if he has to seek migration, then he has to come under the rules for migration. That is not available in a review petition. Regulation 6 of the Graduate Medical Education Regulation has certain criteria based on which only transfer can be done. I'm sorry, migration can be sought from one college to the other college. And is a private seat.
With great respects, my lord, it's not a case of migration as such.
Here, what?
My lords, my entitlement, my lords,
Two,
in
three
that state, instead of not displacing someone else, Notes, I proposed that, notes, if they are not keen on that, notes, the decision, notes, is very clear, note, that is what is related by this court. While avoiding compensation, note, that says, note, the first prayer which is to be granted, when my entitlement is considered, note, it is, my restitution, I should be put in, note, in that position. The other aspect is, note, if I lose, note, an academic year, then compensation.
Will consider reserved for orders.
Please. Please.
So give the appearances, all appearance, usual order.
Please.
Reserved for orders.
I may be permitted to file compilation of decisions. Notes, anyway, they are notes considered.
Do it fast.
Please, I would do it by tomorrow morning itself. Please.
Because he has already been compensated by paying.
No, nothing has been paid in spite of the order. Nothing has been done from the side of the government.
Seeking the review of the order now, my lord. Seeking the review of the order in lieu of the seat, my lord, compensation has been awarded. Now he is come seeking review of the order, my lord.
And you are filing review to yourself.
No, my lord, we have not sought for any review as of now, my lord.
Why?
I pay 1 crore 20 lakhs, my lords, and what is awarded to me is 10 lakhs. My lord, that also, my lords, is not, they are not ready to pay, my lords, in spite of there being no interim order, no petition from their side.
10 lakhs they have to pay in any event. If they are not happy, they have to pay.
Number 42.
APA for the complainant, my lord. My lord, the writ petition was allowed. Writ appeal came to be dismissed. Special leave petition also came to be dismissed. My lord, they were required to implement the orders. What they have done is, my lord, they have put a rider, my lord, which was brought to your lordship's notice on the last occasion. And my lord, they were asked to clarify on that. My lord, that controversial portion, my lord, is it para 9 of the counter reply at page 4 of the reply statement, my lord. I state that since SLP number so and so connected with the so and so concerning granting of proportionate weightage is still pending. Appointment order bearing number so and so dated 18/3/25 in your favor. The complainant herein issued considering the complainant's services. My lord, this cannot be, my lord. In my case, SLP has been dismissed. SLP was filed by them.
Case in question is with respect to proportional weightage, my lords, being given. In fact, in the affidavit itself, I've answered as to why this has come.
16th, please.
Much of that.
43 is adjourned. Number 44. Raghu Yemen.
Very short date to file my reply, your lordship. 18th of June.
Number 45.
That's
Arvind Jain.
We have complied the orders, my lords, that
Number 46. The Maitreyi Krishnan.
I'm filing my reply, my lord, to the compliance affidavit. Fourth of June, my lord.
Number 47. Mr. Satish K.
Lord, I appear for the complainant. Lord, last occasion I have filed a memo producing the order of the apex court, my lord, dismissing the SLP preferred by the state government. Thereafter,
Now, SLP is now dismissed, my lord. We are in the process of compliance, my lord. We will carry out the compliance.
Lord, SLP is dismissed, my lord, on 21/3/2025.
I'll report, my lord. I'll take it. Yes, my lord. SLP is dismissed.
On 21/3/2025, my lord,
We'll do the compliance. Please.
Lord, they have to mutate my name in the revenue records.
Please.
First week of June, my lord. If time permits, my lord, first week of June.
We'll have to carry out the compliance, my lord. We'll have to carry out the compliance. We will do that, my lord, and report it on that.
Number 48, Mr. Dhruv
At
M.
2:30, my lord.
If you do compliance, nothing, sir. Please, my lord.
My lord, the prayer in the writ petition.
I'm the coach.
Lord, let it be pending, my lord. Let it be pending, my lord. I'm sorry, my lord.
Please. Number 48.
My lord, the prayer in the writ petition was to consider and dispose of the application. My lord, the learned single judge allowed that writ petition, directed us to consider and take a decision. We have already taken a decision and communicated it to the writ petitioner. So nothing survives thereafter. And our decision is already under challenge in a separate writ petition. The merit of that decision is already under challenge in a separate writ petition.
No, Your Honor. In fact, last time I made submissions, I've also taken the court to the entire proceedings. What the learned friend has done is that they have produced one statement saying that there's no law. There's no law on the subject, so we cannot grant you examinership license. Yes. Yes, this is at page 10, Your Honor.
Lord, that we have disposed of by an order dated 13/2/2025, which I have produced along with an affidavit. With that, my lord, there is compliance with that direction. Yes. My learned friend has a problem with the merit of that decision, which is already subject matter of a fresh writ petition filed before the learned single judge, WP 5596 of 2025. So he should agitate his rights in that court. If he is unhappy with our decision, he is already challenged it. He should agitate his grounds before the learned single judge in the new writ petition.
Your Honor, the complaints be seen. Your Honor, some third party has filed an affidavit. That person who has filed the affidavit is not even a party to these proceedings. The accused is someone else. The affidavit is filed by someone else.
He has retired.
Who? Your Honor, please see who has filed the affidavit. The person has no relevance in this contempt petition. And second, Your Honor, they state that there is no law. They have given the same examinership license to hundreds of other people. Have they revoked that license from other
It's not
other
true,
people?
I deny that it's a seriously disputed.
Second, Your Honor, if they say there's no law, that means to say my client reserves the right to have freedom to do whatsoever he wants, and they will not interrupt. If that is the submission, then the contempt be taken and disposed of with that submission that my client reserves the right to do whatsoever he wants. Your Honor, for 1 second. Your Honor, one. Your Honor, with profound respect, one submission, Your Honor, just one submission. In that application, have they rejected or accepted my application? If they're rejected also, I'm happy. If they're accepted, I'm happy, but they've not done either of it. No, they have not rejected
No,
it.
he has already
They
challenged
have not
this.
rejected it.
He has challenged this
Your Honor, they
communication.
have not rejected it, and that is my, if they reject it, it will still be in compliance. If they accept it, it will still be in compliance. But they have not rejected, they have neither rejected, neither accepted. And Your Honor, it may be kept post vacation. I'll produce judgments, Your Honor.
Yes.
There's one judgment I want just your lordships to see. And the next submission is that they say that there's a new law which has come into place. They say the Aircraft Act 1937 is not in place. They have not produced one iota of evidence to show that the Aircraft Act 1937 is no more the law, is repealed. Just one judgment, Your Honor.
I'm grateful.
Number 49. Lakshmi Yasola.
Pleading applicant, there is some urgency matter could be passed over. Mr. Raghavan is appearing in the matter.
My lords,
Mr. K.G. Raghavan is appearing in the matter. Could be passed over.
this matter is a
Mr. K.G. Raghavan is appearing in the matter. He's on his leg. Please. He's on his. No, there's urgency, my lords. The order is passed on 25/3 by your lordships without hearing me, and my land is given for a primary health center. Therefore, my lords, there's some.
My lords,
government
they
started
have also
construction.
invoked learned single judge.
My lords, PIL. Your lordships are passed. No, my lords, I am not the PIL applicant. I am the applicant, my lords. Your lordship may just see the order 25/3/24, my lords.
It's a disposed PIL, and he is an impleading applicant who has come under in a disposed PIL. Not maintainable. That's the office objection which is raised.
Your lordship may just take the order 25/3/24, my lords. Lords, there's one they started construction on my property, my lords. They started construction on my property, my lords. My only submission, my lords, could be had to pass over, my lords, or tomorrow, my lords. An order is passed without hearing me, my lords. My land is involved in the matter. It's a temple property, my lords. They have transferred to the primary health center.
Will you just get the pass over and tomorrow or Monday?
Please. Please, I'm very grateful.
50 is adjourned. Seal number 51. Mr. Murali Krishna Brahmanandam, party in person. Number 51.
My lord, he wants to be appointed as an interim mayor.
This is number 52. It's a PL. Mr. SB Mukana.
Petition.
This is number 53. Sumoto petition PA.
My lord, the my lord, there was an unfortunate incident on 12/12/2023, and while disposing of the writ petition, my lord had directed the trial court 6/1, my lord, the direction, page 8.
This is number 54. Okay, Purnimayas.
Please, my lords. Land survey number 96 belonging to a particular Takadiki Tanda, measuring 237 acres, was granted by the then Maharaj of princely state of Aundh, pre-independent India. The said grant was in favor of the entire village. My lord, third party rights have been created. When this belonged to the whole Thanda, the Mukhia's family divided the land. The people went in litigation before the court. That Lord, the interim order that I have prayed for is.
No, my lord, is not granted, and the service is also not complete, my lord.
No, government, my lord, should not oppose only for the because the whole village rights are affected. A single family creates a society. They create collusive agreement of sales in respect of this particular property. They go before the court, file collusive compromise petitions. By playing fraud, obtain awards. Based on the award, they create fake sale deeds. And after when the purchasers came to the disturb our position, it came to our knowledge and immediately we approached. In the meanwhile, certain portions of the land has been acquired for the upper project, and compensation in terms of some crores, my lord, is being awarded. And those people should not take it away. Lord, may I request to have it on second on the reopening day at least, because I'll make it. And certain notices are issued to be certain respondents, answered respondents may kindly be reissued. And service on respondent number 19 to be held sufficient because has been duly served.
Number 55.
I appear for the respondent.
I have complied with the office objection. Second set was supposed to be filed, my lords. I have filed. It was initially filed before learned single judge. Thereafter, my lord, the matter has been directed to be posted before the.
Actually, this is a public interest petition sought to be filed as a private interest.
Much obliged.
Number 56.
My lords, in item number 55, I appear for R4. My name is not shown in the cause list. If the same can be. Yes, R4.
My request any date after vacation. Any date, my lords, after vacation.
Please, serial number. Number 56, Danish Josh Anthony.
Appellant, my lord, IA is filed by the respondent, my lords.
Serial number 57, Mr. Abhinav Ramanand.
This case, appeal for the counsel. My lord, alternate remedy has been directed by the learned judge. There is no illegality in the writ petition order. Alternate remedy is available for inquiry under the Act. This and my lord, the ex parte order of stay was obtained. Though I had filed caveat, my lord, it was my name was not shown, and the ex parte order was obtained. 2:30 p.m.
58 is urgent, 59 urgent, serial number 60.
Your Lordship, appearing for the appellant. Lordship, appearing for the appellant. Your Lordship, this matter pertains to that the appeal, petition was dismissed in the trial court on the because of the ground order 30 rule 10, in which the appellant has filed the claim against the respondent being a proprietorship firm, and the merits of the case was not judged. Your Lordship, I have already made the court fees payment in the trial court for my claim of 55,000. Your Lordship, the office objection is of once again asking me to pay the 55,000 as court fees. Your Lordship, I am asking for the remanding of my petition back so that the trial court can consider my case on merits. I'm not asking Your Lordship for any payment from. Lordship, I can't hear you, Your Lordship.
Pay the court fee.
Your Lordship, I have already made the payment of.
But then again, you have to pay in the appeal. You have to pay the court fee. What is the question?
Your Lordship, because I am not asking any payment from the respondent in this appeal. I am asking for the remanding back of the
whatever you are asking, but you have to pay the court. You have to pay the court fee. Court fee shall be paid as per the office of decision within 4 weeks. Failing it, the appeal shall automatically dismiss without reference to or order of the court. Shall you next? You have to pay the court fee. It's very simple.
Number
Even in
61.
appeal. Yes.
The Maina Verma.
Thank you, Lord.
61.
10th July.
62, 63 disposed. Serial number 64.
64 is furnishing of ETC. Steps to be taken.
64.
Necessary steps shall be
65.
taken. 65 same order. 67 also same order.
67, it's a state appeal, my lords, on the constitutional validity. I request a date be fixed in month of.
Which one?
67, my lords, 67.
67.
Please, state appeal, my lords.
Appeal shall be 67. After necessary steps shall be taken. And if the office objections
It may
are.
not be necessary because connected matters others are appearing. Therefore, it may
We have
be held
served on
sufficient.
most of the private
Will be
respondents.
listed on 16th of.
With your
First
lordship
week,
kind
if I-
permission.
First week, if I may, first week of June, if I may request.
4th of June.
Grateful.
With your lordship kind permission,
30 could it be, my lord?
I represent one of.
Body is not over. Body is not over.
At 2:30, my lord, that is.
No, body is not over. It has been called out.
Please.
So don't mention. So 68,
Number
69,
68
70.
for first time. Office
Grateful.
objection.
Wait, don't call out. 68, 69, 70. The order, common order in each matter. The office of will be complied with within 6 weeks, failing which the petition or appeal as may the case may be in every case shall stand dismissed without reference to or order of the court. So then same order in 71.
Milord, in 71, I appear represent in the connected matter for first
71,
respondent petition.
same order in
Milord, what has happened
71.
in this case
And in
is,
72, instead of 6 weeks, 4 weeks.
Milord,
73, 4 weeks. 74, 73, 4 weeks. 74, 3 weeks. 75, 3 weeks. 76, 3 weeks. 79 up to 79, 3 weeks.
79,
80
Milord.
also 3 weeks. 81, 3 weeks. 82, 3 weeks. 83, 3 weeks. 84, 3 weeks. 85, 86, but separate order you will to pass. 86, 87, all 3 weeks. 88, 89, 99,
One submission,
up
minutes.
to
89 minutes, serial number 89 minutes. That's
up
one
to
request,
92. Now final hearing, yes.
one
Proceed.
submission, serial number 89 minutes.
It is granted now. No,
No, there
this
is
is not the
urgency
matter
in
to
the
be
matter.
debated. You remove the office. And we have no
That's-
time. We have no time to debate about the office objections. It is not our function at all, Mr. Counsel. I don't approve this practice in this High Court, that you go on arguing about the office objections. It is the function of the
I am not
registry.
for the appellants,
So nothing
I am for
going
the
on. Next.
respondents.
We don't have time,
The
Mr.
final hearing matter,
Yes.
number 93,
My lord, in this case, my lord, kindly
number 93.
92, my lord.
92 is office objection.
Yes, my lord, but my lord, what has happened is on Monday, I believe they have served a notice as per the orders passed under page 30. Final order was passed on page 30. Though the alternative remedy was suggested, 70 subclass 2. Despite that, my lord, the votes, the ballot boxes which are
When the
kept
matter
separate
is
has
under
been
office
opened.
objection, we will not hear on.
I agree, my lord. By tomorrow at least, some urgency, because Monday, they'll open the ballot boxes and allow the counting.
Remove the office shall be removed within 2 days. The matter may be listed on 29th.
Till such time, they will not, let them not precipitate the matter.
It is not for.
28th, they are going to open the ballot boxes.
Maybe you should have removed the office objection.
Final hearing matter.
Just day before yesterday, I believe they received the, day before yesterday, they received the notice to open this at page 144,
Now remove the
154.
office objection. When you are
Because
under
of the
office-
extreme urgency, I am requesting.
Maybe we can't bypass the
I-
procedure. That is very clear, Mr. Counsel. We will not bypass, in no case will pass by the procedure. Remove the office.
He will do it tomorrow, my lord, by tomorrow
Often
afternoon.
do whenever you
2:30
today,
may
you
be
do
listed.
right now, today, 28, 29, but the matter will be on 29. If
Right.
you are not able to, then after vacation.
It may be listed tomorrow afternoon, my lord.
Not possible.
Monday, my lord, Monday.
Not possible. Only 29. Yes.
The final hearing matter, seal number 93, Mr. A. Nagarajappa,
What is this about?
PAL.
None is present. Stand over to.
Sorry for the inconvenience, my lord. Senior counsel, there is some inconvenience to the senior counsel, my lord. May be taken up in the next week.
Next week. 6th of May will take.
Please.
6th of May, as requested. Who will come?
Ravi Verma Kumar, sir. Ravi Verma Kumar, sir.
Ravi Kumar Verma will come on 6th of May.
Please.
In this court
Please, my lord.
to argue.
Please, my lord.
All. Chali next. 6th, not 6th, 10th of July.
Seal number 94, Mr. Madhukar M. Deshpande.
Manoj,
94,
I
what is
appear for the respondent.
What is the?
Manoj, on the last date, I was unwell and I continue to be unwell, Your Lordship. I'm not
No.
able to be present in
There is
court.
no. Yes, madam. Yes, madam.
Manoj, I hope I'm audible.
So to be argued or not?
I continue
We'll
to
have
be
it after
unwell,
vacation.
Your
After vacation. So whenever both of you say.
Lord, first week June, Lord, date may.
Which date? Tell us both of you to date.
The first week June.
June 6th.
10th June,
Your Lordship.
10th June.
Please, 10th June. I hope I'm audible, Your Lordship. 10th June is acceptable to us.
Oh, like 10th June. It is not started. No?
Yes, not started.
10th June.
I'm so grateful.
As requested by learned counsels for the parties, stand over to 10th June.
Serial number 91, my lord. Notice to be issued on delay condemnation, but only office objection is that I have not produced the color photographs produced by the original petitioner.
One office objections regarding color photographs is dispensed with. There shall be notice in the delay condemnation.
And the application for stay, my lord.
Returnable on notice in all delay, both
Yes.
applications and appeal returnable on 17th June.
Right to